not to be construed or relied upon as being legal advice for an individual legal situation, or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Welcome everyone to this Monday, December 27th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. I'd like to welcome you all to this TA call this Monday. This is a scheduled TA call. So let's go to Q&A, or not the Q&A, the invite the trust ambassadors, unmute them.
Hello, good evening. This is Eric.
Hi, Eric.
Mike here.
Hi, Mike.
Floyd here.
Hi, Floyd.
Hi. If any of the other TAs are on the call, please speak up. And Lisa, just so you know, Jeff will be joining us tonight. You're going to have to try to find his phone number. I don't know what it is, to unmute him. So if he's trying to speak right now, to let him know he's on the call with us, it might be because he still needs to be unmuted. So welcome everyone to the TA call. And as you know, if you've been with us for the last 6 weeks or so, we've been doing Blackstone's commentaries, and then we've been doing Maxims in order to better understand how to apply a lot of the NTT doctrine that we've been talking about for quite a bit of time. And the more we go through the Maxims, the better understanding that we have of NTT, and the better understanding we have of NTT, the better we can apply the Maxims. So over the Christmas break, I was going back to some older recordings, and I discovered a very key recording, and it was from, I believe it was the 29th of May, right at Memorial Day weekend, and it was Remedy at Law out of CJS, and I was reading the first few pages of that as Christian was reading from it, and there's some very interesting points there that I thought we might be able to take the Maxims that we've been studying so far and have some discussions for some practical application. Because one of the things that's been a mystery for many of us over the course of time is, how do we go from the outlaw side to the private side? This has been this big mystery that I know some of the people who've tried to apply NTT doctrine in their own legal situation, they feel like the private side's been an elusive. Hey Floyd, will you mute out because you're a little bit staticky there?
Oh. Playing football again.
Okay. One of the challenges, as I was saying, or one of the elusive things about applying our knowledge within NTT is in the outlaw side of the court in order to get to the private side. So what I wanted to do is I wanted to share some things out of CJS. It's going to be around page 178. I'll out of volume 30A. I'll get into that in just a moment as far as what that is. But in order to understand the Maxims and the remedy at law, and a lack thereof in special circumstances or in peculiar or particular situations. So, in order to apply the Maxims, I want to bring up this point that Christian shared back on the 29th. I think it was the 29th of May from the recording. So if there's something that you missed tonight from what we read, you can always go back to that recording. And I've been suggesting on the Welcome NTT chat group recently to go back and listen to that recording to prepare for this evening. And then also this evening we will be getting back into the Maxims as well directly out of CJS. So in order to start with this, and this I am not sure whether or not it's posted at the download site, and unfortunately I don't have a flatbed scanner to share this portion of CJS. If it does exist at the download site. I believe Night Train has maintained a lot of the downloads and offered them for people. Please post that on Welcome NTT and make everybody else aware. And before I get into tonight's what we'll be sharing out of CJS, one thing I want to say is for everybody on the call who's joining us, new people, please contact Faith to Trust on Skype in order to be added to the Welcome NTT group, in order to get access to the downloads and all the books that we reference, and also all the recordings from past shows. And also, please, people volunteer to be transcribers of these of these calls, because we are finding as trust ambassadors, though, those out there who are new, who are transcribing, are becoming some of the most effective people in learning NTT. And the only way to learn this is to do it. And the other thing I have to say for the new people is be patient, listen to the recordings, and listen to them again and again and again. And then if you have questions, come on to the calls and bring up points about past recordings so we can discuss this. Because if you don't do that and you can't break through that point where you're stuck, please come on here and help and ask us or ask Christian so we can help you through it, because it might just be one little thing that you need in order to get through, and to go back from the beginning and listen in order to get a better understanding of what it is we're talking about today. And a lot of the things we talk about things from right from the beginning, from 11/7 to 2009, but also we talk about new issues of today that we've been studying, for example, as a group of trust ambassadors. Also, in order to get signed up for the NTT Beginners 101 course, please send an email to movingtitles@hotmail.com, and in the subject line, please put NTT registration application in the subject line in order for a Christian to send you one out. And then soon we will be announcing the date of when that will begin. So again, Moving Titles at Hotmail, and in the subject line put NTT registration application in order for a Christian to send you a application to get signed up for the course. And then once we have you signed up for the course, we'll send you study materials to prepare, and then vocabulary list and things that you can get familiar with in order to have some working knowledge for the course. So. And if any of the other trust ambassadors want to add anything in the beginning, that any issues they might have heard about recently that we might be able to discuss for tonight's call, please come on now and state that at this time.
Could you add my name to the group, please?
We'll add your name to a group, Mike. Don't you worry. All right, I take it that Floyd and Mike don't have anything to add at this time. One of the things that I found, and that I want to bring out first out of the remedy at law section, is the two reasons that we're going to try and attempt to get into equity. And this was something very substantial, and I have to pick it out of the context, and then we'll do a little bit of discussion about this, and then we'll go back to some of the other and bring this into context. So bear with me a moment while I find it. And this is on page 180 in section of lack of remedy at law as ground for limit of jurisdiction. Okay, and I'm going to grab this out of the context. And on page 180 in section 18 of CJS of volume 38, this says the theory that the rule of equity will not take jurisdiction where there is an adequate remedy at law is to be taken as indicating the origin of equity jurisdiction and as defining generally its grounds and objects is more generally adopted than the theory that the existence of an adequate remedy at law is a constant limitation on the exercise of jurisdiction. Where the latter theory prevails, the courts in adopting it have generally been influenced by statutes and terms restricting equity powers to cases where there is no adequate remedy at law. But in other jurisdictions, such language in general statutes is held to be merely descriptive of and not intended to restrict equity jurisdiction, and as not precluding the broader doctrine. And just bringing up that point in order to see our way clear in where we might be forced into the at-law side of the court, the public, opposed to being pushed into the private. Or not pushed in, but leading ourselves into the private would be a better way to say it, to repudiate their repudiation, and in order to make it our jurisdiction. What kind of situation do you think you might want to employ, Mike, in order to take advantage of in other jurisdictions, such language in general statutes held to be merely descriptive of and not intended to restrict equity jurisdiction and is not precluding the broader doctrine.
You're talking to me?
Yeah, I'm talking to you.
Well, what are we trying to do here? We're trying to get in the equity side of the court.
Right, and I was saying what type of situation where it says when we bring it in this context right here, where such
the situation, the only situation is the trustee is not acting as a ordered or breach of trust. In other words, creating a fraud. That would basically the only reason to get into equity, a reason why we would want to. Because if they went ahead and did what the indenture did, we wouldn't be trying to get into equity. You there?
Yes, I am.
Okay.
Really what I was getting at for the context that I brought up, and this is just a little bit of foundation in order to utilize this context, and that is when I read it, but in other jurisdictions such language in general statutes is dealt to be merely descriptive of and not intended to restrict equity jurisdiction, and as not precluding the broader doctrine was to do a withdrawal and redeposit when we observed that these general statutes is held to be merely descriptive of, but not exclusive, and if we put the mirror to that, but not exclusive of equitable jurisdiction.
Yeah, but the bottom line is if the trustee doesn't pull us out of general and put us into special, then he has basically breached his fiduciary duty, and then that's what brings us into the court side of it. And then there also we can, once we get, once we get into the court, okay, we have to do fine for, can't think here, not disclosure, but we have to, discovery, which will stop the running of prescriptions, and then we can get in there and go from there as far as getting into the equity side. Because, do you agree?
Well, yeah. What I was trying to do is I was just trying to lay down a little premise for the rest of what we'll be discussing tonight, and then to build upon it, and just to lay down that where the general statute is held to be merely descriptive of and not intended to restrict equity jurisdiction, and as not precluding the broader doctrine, was in order to only to keep the statutes descriptive of and not restrict. Well, that's where the doctrine of NTT steps in, and that being the withdrawal of the general and redepositing special. That's the point that I was trying to get to lay on what I'm about to go with next. And this right here is going to provide some very good stuff for conversation. The rule that equity will not grant relief where there is an adequate remedy at law applies only when on the case stated there is a legal remedy. A distinction is to be observed between a case cognizable at law, but for which law has no adequate remedy, and a case that can be adjudicated on its merits only in a court of equity. In the one, the equity court is invoked only for a remedy. In the other, for an adjudication of the rights of the parties on the facts. Where the pursuit is properly cognizable in equity, the existence of an adequate remedy at law may justify a court of equity in refusing to entertain the matter. Where the matter is legal in nature, the absence of an adequate remedy at law is necessary to confer equitable jurisdiction. If on the facts stated, the case is of a nature cognizable only in a court of equity, plaintiff will not be shut out of that court on the suggestion that on another state of facts he might recover that which would be equally satisfactory in another tribunal. So do you see the distinction as to why we might, two reasons we might go into a court of equity, and why we, and the two realms of why we might enter in there?
Well, Eric, then what you're basically stating is that you don't really go into equity until you know you don't have a remedy at law, which we know we don't have remedy at law.
No, that's not what I'm getting at, okay? I'm talking about when we go into equity, okay, there's going to be, for our, let me make sure I get it right out of CJS here, where the law has, where a situation cognizable at law, okay, a distinction is to be observed between a case cognizable at law but for which the law has no adequate remedy and a case that can be adjudicated on its merits only in a court of equity. In the one, equity court is invoked only for a remedy. Equity court in the one is invoked only for a remedy. In the other, for an adjudication on the rights of the parties on the facts. Do you see the two reasons why we would go into equity now?
Well, the rights on the parties and of the facts, that would be equity, wouldn't it?
Yes. Also, it would be equity for the invoked only for a remedy because there's no adequate remedy at law, so we would go into equity.
Okay, right.
Okay, so in the realm of NTT, we're going to go in on both realms, but there's going to be two premises upon which we go, is what I'm getting at, based on what's here in CJS. Because on the one, there's no adequate remedy at law, and on the other, it's for an adjudication of the rights of the parties on the facts. And right out of CJS, we got that there's two premises as to why we would go in.
The rights of the parties on the facts.
And because there's no adequate remedy at law. For both is what I'm getting at, is what we have to argue.
Oh, okay, sure. All right, I see that. All right, I couldn't. Because we've been saying all along that we have to be coming into equity on facts and on rights.
And on the premise that there's no adequate remedy at law.
Yeah, right, exactly.
The thing is, you need to rephrase this, Eric, because you're very confusing. Okay, because if you can't have any remedy at law because you don't get any rights at law.
That's right. Yeah, exactly. At law does not distinguish anything about rights. In other words, it has no premise of rights, whereas equity is the premise of rights. In other words, we're dealing with the rights of the individual in equity, and that's the only place that you can deal with the rights of the individual is in equity.
Because you can't get any remedy at law because at law cannot see your rights.
Because they can't see you, because they can only see natural rights, endowed rights.
They can't even see natural rights.
Right, because we're nothing but a fiction. And just to share with everybody for a moment, Christian has asked us to share that we would go in for a declaratory relief, and no, because there's no adequate remedy at law, and we adjust both sides of the ledger in this action, private and public. And I'm sure that he's sharing that in reference to there's no adequate remedy at law and for an adjudication of the rights of the parties on the facts. So that's both sides right there. There's no adequate remedy at law, no adequate nothing they can do on the public side. So we go in for that side there, and then the private would be the adjudication of the rights on the rights of the parties on the facts, and private is the declaratory relief. Public is no remedy at law. So right here in CJS, he shared with us.
Eric, take your time here and rephrase that because you're very confusing right now. On the at-law side, what occurs?
On the at-law side, we're going to declare there's no adequate remedy at law, and for that reason, we're going to we're going to argue to go in the private equity.
Absolutely. Now that's a little bit more simpler to understand.
All right, and going back to bring this full circle, I'm going to read what's in CJS again, so we get a deeper understanding of it. The rule that equity will not.
Now, you have to remember what is CJS.
Well, they actually.
That is not pure equity. That's talking about both sides. And
I agree.
When you read it, you have to explain which is which when you're reading it because it's very confusing.
And I appreciate that, Mike. And the fact that it's pointing out both sides to us as to why the dual reasons that we go into equity, private equity, actually exist, and it shows us both the public and the private reasons that we would go in. The private foundations, the private evidence, the private foundation is really probably the best way to say it. So I'm going to read the paragraph again. Now that we had a little discussion, I think it's going to make a lot of sense, more sense to people. The rule that equity will not grant relief where there is an adequate remedy at law applies only when on the case stated there is a legal remedy. A distinction is to be observed between a case cognizable at law, but for which the law has no adequate remedy, and a case that can be adjudicated on its merits only in a court of equity. In the one, the equity court is invoked for a remedy, and the other for an adjudication of the rights of the parties on the facts, where the suit is properly cognizable in equity, the existence of an adequate remedy at law may justify a court of equity in refusing to entertain the matter. Where the matter is legal in nature, the absence of an adequate remedy at law is necessary to confer equitable jurisdiction. If on the facts stated the case is of a nature cognizable only in a court of equity, plaintiff will not be shut out of that court on the suggestion that on another state of facts he might recover that which would be equally satisfactory in another tribunal. Now, what do you think they mean by another tribunal? That is definitely something I'm in the dark about. I don't know what they mean by another tribunal.
Eric?
Huh?
Eric?
Yes.
Yeah. Can you hear me? This is Jeff.
Yeah, Jeff, we can hear you loud and clear, my friend.
Okay, good.
By the way, introduce yourself since you just came on the call.
Yes, this is Jeff from Washington State, one of CW's TAs.
Welcome, Jeff.
Yes, I've been listening to the reading, and I wanted to point out that we've seen several times in here where they've talked about the remedy by facts, and we have to understand that that is statutory. We get our relief in equity, so if they're tying in a remedy to facts, then there's equity doesn't see facts. And as per the other tribunal, I would say that that tribunal is the one that you will get in the in-camera proceeding.
That brings up a very interesting possibility. But one of the things that I want to point out that you just brought up is actually the relief, according to what this text says, the relief is by fact, and the remedy is because there's no adequate remedy at law, so it becomes equitable remedy is the way that I'm interpreting this. Because if they can't provide fairness at law, then we go into equity for that remedy within that realm. That's really what I'm getting out of this. And if you guys are getting something different, please speak up.
Let's read that again. Was that from?
That's 30A on page 180. But I'll read it again right now. You ready?
Yeah.
Okay. A distinction is to be observed between a case cognizable at law, but for which the law has no adequate remedy, and a case that can be adjudicated on its merits only in a court of equity. In the one, the equity court is invoked only.
Hold up right there. First we had something that's cognizable only in equity, right?
No, it says between a case.
It's cognizable only in equity. That's the private side.
Wait, this is what it says. I'll read it again. A distinction is to be observed between a case cognizable at law, but for which the law has no adequate remedy, and a case that can be adjudicated on its merits only in a court of equity.
Well, now that court of equity is their public equity. It's not our private equity that they're talking about right there.
Not necessarily.
I don't think there's any adjudication of facts in the private. There's only one thing that's looked at in the private, and that is right. That's the only thing that equity sees is a right. So if they're talking about facts and they're talking about adjudication in equity, they're talking about their statutory equity. That's the way I see it.
But we still have to have the facts that are going to point to the rights.
The facts are colorable. We only give colorable facts so that we can move them into equity. But once we're in equity, we don't need facts. We show our right, and we say that our right has been denied, and that's why we're going into equity. So when we read these CJS, we have to determine which equity they're talking about.
So when they say equitable remedy
is statutory. Equitable relief is private.
Right. Equitable remedy can only be had in statutory equity. Equitable relief is not possible in the private. Just to make sure we draw the line, that line of demarcation.
Right. There's a line there.
Okay. And then
page that I've got these pages. I'm trying to get to them. What page was that again that you were reading from?
It's page 180. It's section 18, Jeff. And so that's the reason I wanted to bring this up, because this is a very important point that we need to recognize in traversing through these through the realm of through the at-law into the private to understand what's equitable remedy and what's equitable relief, because these can become some very confusing terms for a lot of folks. And then through what I'm bringing up here, I want to take the maxims and I want to talk about how the maxims might apply to different situations where we might find ourselves.
Right.
Okay, so I thought that this would be a great way to start out because this is a big question for a lot of folks. So we'll have some application here is really what I'm getting at. So on the one hand, we have a court of equity that can, for which the law has no adequate remedy, and a case that can be adjudicated on its merits only in a court of equity. In the one, the equity court is only invoked for a remedy, and the other for an adjudication of the rights of the parties on the facts.
Okay, now you have statutory adjudication of rights of the parties because the parties believe that they are expressing rights at law, but they're really not. They're expressing facts, and that's all that at law can see. So those rights that they're talking about are not what we in the private side deem as our equitable right. For instance, can you go back to the paragraph that starts with the principle of it is the basis for many forms of equitable relief? It's probably at the beginning of the maxim.
Which page on, Jeff?
Well, I'm using a different I'm using a different version, different edition.
Well, what section are you in?
121 equity.
Oh, I'm in section 18, so we got to go on. So we're going to grab section.
Oh, okay. No wonder I haven't been following you.
Right. I wasn't bringing this in. I wasn't bringing up the maxim first. I was bringing up a big question that people have been having a challenge understanding because I've had the question of I can't find private equity. So we need to understand what that line of demarcation is between remedy at law and relief in equity.
Right.
And that's why when I was listening to the recording from 529 and I heard Christian reading this out of CJS, I said, this is something critical to bring up, and then we can take our working knowledge of the maxims and apply it to this and have some discussion and then bring up some of the stuff from Pomeroy and Snell's book, and then we can take this stuff we're trying to do today and use that stuff and apply it and bring it full circle is really what I was getting at. So do you have a page, do you have section 18 in CJS, Jeff?
18?
Yeah, section 18.
Oh, that's real early in the book, isn't it?
Yeah, it's under remedy at law.
Yeah, give me a minute or two to go get it because it's in another
That'll be fine. Take your time.
file. Yeah, I thought you were reading 121 and I was going, wait a minute.
Wait, something's not lining up here. I understand. Yeah, we'll get to that in a little bit. So since I suggested that everybody go back and listen to the recording, I've had some comments on Welcome NTT where they were stating, for example, as sometimes stated, equitable remedies cannot be pursued until all legal remedies have been exhausted. Well, everyone recognize that it's on the at-law side, and that's very important that you realize that on the at-law side that you're going to be barred from an equitable remedy. So you're going to exhaust all the statutory requirements that exist on the general deposit side or on the at-law public side, on the legal side.
Now, we talked about those switches.
Yes.
And those switches are what help you determine which side of equity you want to get into.
And just so everybody knows, the heading of Section 18 is lack of remedy at law as ground and limit of jurisdiction. And if we take the phrase limit of jurisdiction, that ties into something Christian brought up recently about the Rule 1.170J out of the Florida Rules of Court of transfer of action, and in that is within that rule is a jurisdictional limitation as to why we need to get it dismissed from the outlaw side so we can bring it over to the private side. So,
can I interject here?
Sure.
I just want to bring it to everybody's attention. I know that we are looking at CJS as basically the Bible, but we have to keep in the back of our mind that CJS is working with DC at the at-law side. And just because it says, like Jeff was saying earlier, because it says it's equity, it's statutory equity, it's not the equity we're looking for. And we all need to be careful when we're reading this. We've got to look deeper. And that's when it talked about that one paragraph that he read about 5 minutes ago, where it talks about going into that special chambers or that special courtroom. You recall that, Eric?
What is it you're talking about exactly?
Well, I'm talking about the paragraph that you're reading.
Other court or whatever that.
Yeah, the other court. I mean, that's the equity that we're looking at, and this is why you need to be very careful when you're reading the CJS, because it's the statutory equity. It's not the equity we're looking for, but it tells us how to get into the equity that we're looking for, the private side equity. And you need to put on your equity eyes, the private equity eyes, not the statutory equity, because they will draw you into the statutory equity, which is not where you want to be, and you're going to end up getting screwed. And this is why what I was trying to explain earlier is, like Jeff came and clarified, and I appreciate that he did that, is he had the eloquent words to present it properly, is that the only thing we're looking at is the equity side that we're looking at is the rights. That's it. That's the only thing that we can discuss. It's not the facts.
And Mike,
the facts have nothing to do with our rights. That's our rights, our equity rights.
And Mike, to support your point, here on page 179, down below in the footnotes, we have a footnote that says peculiar and extraordinary cases. When peculiar and extraordinary cases arise, customary forms of ordinary law are often not adequate, and fiber of legal thought necessarily must be woven from equitable principles.
It says it right there.
That's
how they hide it down at the bottom of the page.
Right.
Well,
so,
I don't know if they hide it, but they are editing their text from it, Jeff. That's
because they're basically hiding it because they want to keep people in the statutory equity and not the private side equity. And this is what we're striving for. And these are colorful language. We have to be able to see through it.
But Mike, to be fair to CJS, they're not hiding it. It's right below in the footnote. Just to be fair.
I'm not saying CJS is hiding it. I'm saying the authors are hiding it.
Could I point out one thing, guys?
Sure.
Go ahead.
I would just like to point out that until Christian began to teach NTT, there was no one that was using private equity. And until he came along with NTT, all there was known to anyone was the equitable side of the private side of equity. So I think that's one of the areas that we need to keep in uppermost in our minds when we're discerning equity. And what Jeff just pointed out a few minutes ago only brings that point to into focus.
Thank you, Floyd. And we never once, back from before 11/7 of 09, we didn't think we'd be sitting here having a conversation about picking CJS apart and going, hey, remember CJS is written from the public side, from the DC side. We never even thought we would be having a discussion such as this. So, great point, Mike. Great point, Floyd. Great point, Jeff. And isn't it great that we can sit here and have this debate and bring important points out for everybody to recognize, so when they are standing in court and they're observing, and by the way, everybody go to court and watch and see what's going on so you can see how the private is being hidden. Go and do that before you have a case and you're in the hot seat, because I promise you're not going to feel the same if you've never been there before compared to if you go and observe. And I think it's critical if anybody has a case going to go and observe and spend some time there.
Also, Eric?
Yeah.
I think this is a point where we should really tell our group that how necessary it is to really listen to those audios and then read CJS, not the reverse.
Thank you, Jeff.
Because in the audios, Christian talks about these words: peculiar, extraordinary, equitable, adequate legal I mean, he's already brought all this stuff out. There's no need to say that we're lost in this stuff, because we have the audios and we can go read the CJS and pick and hone out of there.
Yes, I agree. Absolutely. The previous audios from 11/7 of 09, for anybody that's new, again, we can't. That's how we all learned all this stuff. We didn't just get all this private tutoring from Christian. We listened to those audios for many hours to get a working vocabulary of what we're talking about here, and to have the set of eyes in order to for us to be able to look at CJS and see both sides of it. These words and these paragraphs really come alive in a way that they couldn't have without listening to those audios. So we didn't just figure this out overnight. We put many hours into participating in the calls and coming on and asking questions and having discussion and going back and listening to the answers many times over from the questions that we developed. So, but we could go back to what we were talking about here, and as we're going through this, guys, start thinking about how some of the previous maxims that we've discussed, how they apply to this context, and how we might be able to look at this and go, oh, this one fits, that one fits, that one fits, in order to do some application. So if you guys would look at this with that in mind, that way when people are thinking about how they're going to go from one side to the other, how they're going to go into one side, do what they got to do on the one side, and then get over to the private. If we could look at the maxims in order to give them the foundation so that they'll have the confidence to traverse that in that fashion, that's what I was really hoping to share tonight. So, does anybody see the application of any of the maxims in some of the things we talked about so far? Did I lose you guys?
No, I'm thinking, because every equitable maxim applies to everything that we've said tonight.
Thank you, Jeff. I agree. Everyone.
I could defend each maxim for each of the things that we read tonight. So I'm trying to think of one that's the best.
Well, I got one that, since you brought it up a little while ago, and we will be discussing it in a little while, in the text that I read, where it says, in the one, equity court is invoked only for a remedy, and the other for adjudication of the rights of the parties on the facts. Well, that right there, Section 121, equity regards that as done which ought to be done. Well, the adjudication of the rights on the parties of the facts, there it is right there.
Ought to be done, to my thinking, is an absolute term in terms of something that was done previously that set it up automatically. For instance, transferring trust res to the trustee. Now, if you go into a court at law and lose, then they have violated the maxim that says that equity will do what ought to have been done. What the court ought to have done is recognize that the trust was created, the trust was established by the transfer of the res. So that's a point where you could bring in the maxim that what was done was what ought to have been done. And that is that the trustee ought to have performed because the trustee had received the transfer of the res. So that's a place where the maxim is showing that the relief must be granted.
It's the foundation of all maximum. That's the ultimate one. That's the core.
Actually, he who seeks, I think, is one of them. Well, they're all integral. You can't say one is more core important than the other, because they really are. That's why they're all called maxims, right? But no doubt about it, that is definitely a foundational premise, both Jeff and Mike. And then I was thinking about he who seeks must do. So if we take that same phrase, in the one, the equity court is invoked only for a remedy, in the other, the adjudication of the rights of the parties on the facts. Well, in the other, if we're going to seek equity, we must do equity. Well, for the adjudication of the rights of the parties on the facts. So we gotta know how to do equity in order to get the adjudication for the rights of the parties on the facts. If we're going to seek, we must do what we have to do, process and form wise, in order to get our adjudication for the rights of the parties on the facts. So that maxim effectively applies there. And then that adjudication also would bring in he who equity delights in doing justice and not by halves. So that adjudication would be for declaratory relief of the rights in the private. What other maxims do you see apply just for that adjudication of the rights? Equity aids the vigilant, not those who...
Is the one that compels performance?
You talk about Equity Act specifically?
Yeah, there's one that that's what we're going into equity for, is to have the trustee, for instance, be compelled to perform, because that's what our right is.
And that just so I think that the maxim of Equity Act specifically is the one you're referring to, Jeff.
Might be. I thought there was another one. I don't have the list in front of me. I think we need to go back to this phrase, though, again, the adjudication of the rights.
Of the parties?
Of the parties. I still think that's statutory.
On the facts.
On the facts. We should look at that entire paragraph that's there and read the entire paragraph and see how that fits into because we are not seeking any kind of adjudication on our right. The reason why we don't need to is because equity will do that which ought to be done. We don't need a court to adjudicate whether we transferred the res. It's already been done. And equity will look at it in camera proceeding and say, the trust res was transferred. The court ought to compel the trustee to perform. That's not an adjudication because the fact is already existing before the case came about.
So you see what Jeff is trying to say, Eric?
Yeah, I know exactly what he's saying. And so what I did is I went and grabbed the definition of adjudication just to make sure we have a clear understanding. And of course, out of Blacksforth, it says the giving or pronouncing a judgment or decree in a cause, also the judgment given. It implies a hearing by a court after notice of legal evidence on the factual issue involved. And contemplates that the claims of all parties thereto have been considered and set at rest. The term is principally used in bankruptcy proceedings, the adjudication being the order which declares the debtor to be bankrupt. So if we take that definition and we put it into adjudication or the judgment given of the right of the parties on the facts, well, what if we don't present our facts properly so there can be no order so the judge can see a trust? Because we need that power from that judge who has that power to set the enforcers of law against those who've injured us because they didn't specifically act with specificity.
That's where your procedure comes into play. You have to know what you're doing and have to put forth the procedures before you go into court. And just like Jeff is explaining, is that you being the king, that act has already been done. Now they can sit there and say, no, we never got this. Well, I've got the documentation that you did it. The act has already been done. Why aren't you doing it? And that's what the judge is going to compel the trustee to do his job. If he doesn't do his job, then the judge has the right to get them in contempt of court now.
And that'll be a judgment for contempt.
That's right, at the outlaw side.
Right, and that's what we're talking about here is an adjudication of the right of the parties on the facts. So the judge will find the other party, the liable party, the trustee, in violation or guilty.
What are the facts? What are the facts? You keep cluing in on this word facts. You think it's important. What are the facts you're talking about?
Well, what we provide so the judge can see the trust, so we can pass the trust test. That's going to be our records.
Which is.
But we can only show that in camera.
That's right.
No.
We can't put that in.
No, there's going to be facts that we're going to use to support our bill in equity in the public. Our affidavit.
Which are?
Our affidavit that the facts exist.
An affidavit
you're telling the facts are really what we really mean is a colorable term. So
we have to on the colorable side.
It is facts, but we don't expose it as a fact.
Yes, you're right, and thank you for bringing that up and pointing that out, because we do need to call out on the public side what's colorable and what's on the private side as being true evidence.
My thinking lately, Eric, is that we seem to be writing cases to win in the lower court, in the lower level, and I'm just thinking nowadays that perhaps we should be writing for the Supreme Court, state or federal, because those guys up there are the ones who understand equity and trust. If we write for them instead of writing for the lower court, then when we get run over by the lower court, we're not surprised. And it gives us the opportunity to present it to those who know what they're talking about, what they're reading.
Well, then let's point out for the folks on the call with us that they're going to have to potentially deal with getting run over by the lower court in order to go to that appellate level and supreme level.
Right. That. When we start walking down this road, we cannot have the idea that we're going to win in the lower court, because most of these lower courts are either set up to obstruct us from getting into equity, or they just don't know. The true test of our knowledge is that we're able to go to the higher court. We know how to do that. We know how to write for them, and we know how to get in there.
And that makes perfect sense when we think about being a general depositor compared to...
Exactly. That's exactly right.
Somebody ourselves.
I think what Jeff is trying to explain is that when you're presenting your case in the lower case, write it for the Supreme Court. In other words, put it in the Supreme Court decision, the appellate court decisions, and everything else. And don't write it for these lower courts. You're addressing the Supreme Court. Now, if these guys, these idiots down below, don't see it, which they more than likely won't, you've already got your brief already set up. The case is already presented. All you do is go and appeal when it goes into the Supreme Court, and you win right off the get-go, because you've already done your homework. That way you don't have to represent the case. All you're doing is on an appeal.
And Mike, I agree with you, and that's also consistent with what Graves said in jurisdictionary. And at this time, I'm going to go ahead and tell everybody, if you don't have jurisdictionary, get it. It's that important so you can understand what's going on at a much deeper level in the outlaw side. And also, oh, by the way, I found some YouTube videos on jurisdictionary. So if anybody wants to learn some things about jurisdictionary, go on YouTube and take a look. And there's not a lot there, but there's definitely a few nuggets that'll get you understanding how important that is to everything that you're doing here.
Well, that's a lot of information. I haven't looked at jurisdictionary yet, although I've known about it for many, many years. And, that's just another book to read kind of thing.
No, Jeff, let's not discount it, and let's not scare people with it. It's a lot of information, because when we first got into NTT was a lot of information, but look how far we've come, and it really hasn't been, when you look back on it, it really hasn't been that hard, really, has it?
Oh, it was at one time.
Well, but you got past it, and let's...
The jurisdictionary is basically a format to get into the court of how to set everything up. But, this device will help you, but you also have to do extensive research to do appellate court cases inside them in your original brief that you're putting into the lower courts that is already been adjudicated on the Supreme Court level.
Right, but I just want to make sure that everybody's aware how important jurisdictionary is at this point, especially if you're just coming in NTT. The recordings, the transcriptions that are available, that you can get all the links to this stuff through Faith to Trust, and jurisdictionary will give you a working knowledge, and of course going to sit and observe cases. These things are all foundational to your to people getting a working ability to understand NTT. So. The other thing that I wanted to point out that Christian's talked about, and this is on page 181 of CJS, that we need to be aware of anytime we get involved in a case is concurrent or exclusive jurisdiction. Because the outlaw side and the equitable, the private side, can run simultaneously, concurrently. And we got to stop the outlaw action in order to do what we got to do to get our relief and equity. And I got a section 19 in CJS that I want to share in order for people to get a little bit more understanding so they don't get hammered by the outlaw side.
Section 19?
Section 19, it's on page 181, Jeff. Concurrent or exclusive jurisdiction. Where the jurisdiction of law and equity is concurrent, plaintiff is not necessarily compelled to resort to his legal remedy, but it may be within the discretion of the equity court to determine whether it will assume jurisdiction. Where exclusive jurisdiction to adjudicate a matter has been placed by the Constitution or statute in some other court, the Chancery Court is totally without power. And before I get into the text of this, Christian shared with us that there's three divisions in equity: exclusive, concurrent, and auxiliary. I'm going to repeat that again, that people recognize there's three divisions in equity, and it's one is exclusive, two is concurrent, and three is auxiliary. The jurisdiction of a court of equity is sometimes concurrent with that of a court of law, and sometimes auxiliary to it. Wherever equity jurisdiction has been once established and a remedy at law is subsequently created or made effective, and whenever a case is a class cognizable in equity, but the circumstances render a legal remedy available in that particular case, the jurisdiction of law and equity is concurrent. In such case, plaintiff is not compelled to resort to his legal remedy, and he may seek relief either at law or in equity. The mere fact that a concurrent remedy at law exists does not oust equity of jurisdiction, and even though a remedy at law may be available, the remedy in equity is still proper, particularly where the legislature may give such remedy as being more flexible or better adapted to the particular circumstance than the remedy at law. It has been held, however, that even in this common field, it is the sound discretion of the equity court whether or not it will assume jurisdiction in a particular case. The matter to be determined in accordance with the circumstances of that particular case and the relief sought, and of the particular, and that as a rule, the equity court will not do so if the remedy at law is plain, adequate, and complete, unless there are some features of the case which make it more appropriate for a court of equity than a law court to handle. Equitable cognizance being usually declined where there is a wholly effectual remedy at law, and there are no special circumstances calling for equitable interposition. In cases of concurrent jurisdiction, the tribunal, which first acquires jurisdiction of the subject matter, may, in its discretion, proceed to a final disposition in the case. Guys, we're going to go back to that in a moment. When one court assumes jurisdiction, the other court must therefore not attempt to act in the same manner unless good reason is given for the inference of equity. Where equity is invoked, its jurisdiction will not be defeated by subsequent proceeding at law. If the action at law is first commenced, equity will not assume jurisdiction without the intervention of some special cause rendering the jurisdiction at law inadequate, as where the court of law is unable to grant the full measure of relief available in equity. Now, I know as I'm reading this, all kind of stuff was going off, so who wants to add something first?
Well, Eric, you know, in what you read, it's all about the court making the determination where it goes. There's nothing in there about me making the determination where I want it to go.
Well,
did you notice that?
I disagree. I disagree because as soon as I saw the word special, I know that's me moving that court in the direction I want it to go.
Right.
Until the word special came up, you're right. Absolutely, Jeff. And that is the foundation of our doctrine here at NTT, and thank you for pointing that out. And another thing that I wanted, I wanted to point out here is, in cases of concurrent jurisdiction, the tribunal which first acquires jurisdiction of the subject matter, in its discretion, proceed to a final disposition in the case. That, to me, is what Christian's talking about. Is we got to stop the outlaw action in order for us to perfect or to bring out our outcome in the private. Whatever we got to do.
How do you do that?
Well, our declaration of our law form destroys the at-law side. Have our declaration that we're using the 1776 law form, which promises unalienable rights. That right there, if that's in your paperwork, in my thinking, that destroys that law right there, and anything that they're doing.
Well, let's hope that destroys it, because I personally haven't applied that yet, so I can't say with factual evidence that it's worked for me. However, let's look at the fact that in cases of concurrent jurisdiction, the tribunal which first acquires jurisdiction of the subject matter in its discretion may proceed to a final disposition. Okay, so we got to look at what's going to stop that at-law side while we perfect our bill in equity, while we put in our counterclaim, while we go after what we're after. So,
well, it's got to be an at-law tool.
Thank you. An at-law tool that is equitable, and you know what that is, right?
Yeah.
Discovery.
Right.
And there's some very interesting things that we can do with discovery.
But the bill in discovery is actually a component of the bill in equity. So when you put in the bill in equity, then that should be the stopper.
So so as I read through this remedy at law section, and we're looking at what we can do to stop that during cases of concurrent jurisdiction, I just wanted to point out that that's what we're going to do. That's the tool we're going to use to stop that, so we can put in our counterclaim, our bill in equity, to get their case dismissed and get that transfer of action over to the private. Utilizing, for example, here in Florida, 1.170J, transfer of action.
Right, I read that. Yeah.
Okay. So that was a big part of this that I wanted to share with everybody. When we do, Christian's writing something, so we'll share what he has in a moment. So Christian said the counterclaim is our bill in equity. If I didn't make that clear, everybody, I apologize. So that's the other thing I wanted to bring out in this remedy at law section, that I was hoping that as we're reading through this, we could take the maxims and apply them, and again do some application for our understanding of the maxims. And Christian also shared that a counterclaim is auxiliary. And remember, the three divisions in equity are exclusive, concurrent, and auxiliary. So as I read through that, were you thinking about how we can apply the maxims to that, Jeff?
No, I wasn't.
Oh, well, let's take it paragraph
but I will do it now.
Okay, let's take it paragraph by paragraph, and we'll discuss it, because as much as we've talked about the maxims in the past, and I know you have a good handle on them, this is a good way to apply to give people some practical applications. So the first paragraph, again, is the jurisdiction of a court of equity is sometimes concurrent with that of a court of law, and sometimes auxiliary to it. Wherever equity jurisdiction has been once established and a remedy at law is subsequently created or made effective, and whenever a case is of a class cognizable in equity, but the circumstances render it a legal remedy available in that particular case, the jurisdiction of law and equity is concurrent. In such case, plaintiff is not compelled to resort to his legal remedy, and he may seek relief either at law or in equity. What maxims do you think can apply when we might seek our relief either at law or in equity? Perhaps equity acts persona.
Yeah, that's true. That's one.
And then also, if we may seek our relief either at law or in equity, how about where equity follows the law?
Well, they're not engaged in law. They're engaged in statutes and codes.
Well, but let me share the first line out of equity follows the law out of 118. Equity is ancillary and not antagonistic to the law. It has never been an instrument of law violation. It is frequently stated as a maxim that equity follows the law. The maxim is a fundamental principle of equity jurisdiction, and it is just as potent as the clean hands doctrine. One meaning of the maxim is that equity devises means for enforcing a lawful result when legal procedure is inadequate. In a broad sense, the maxim means that equity follows the law to the extent of obeying it and conforming to its general rules and policies, whether contained in the common or statute law. So when we look at the last line in such case, plaintiff is not compelled to resort to his legal remedy, and he may seek relief either at law or in equity. Well, if equity follows the law, then we might have that opportunity based on that maxim. Would you agree?
Yep, I would.
Okay. And if you see the other maxims, how they could apply in concurrent or exclusive jurisdiction as far as application, if you want to.
Well, there is that one maxim that says that when the equities are equal, then the law will prevail. Is that following from what you just said?
When equities are equal, then the law will prevail. Well, let's break down what law we're talking about here, my friend.
But let's also break down what equities we're talking about.
Yeah, perfect. Now we're getting hit the pay dirt. I like this. All right. So the law we're talking about is all lawful because we created it because it's an agreement among real men. It's a relation. It's a trust. That's the law we're talking about.
Yeah, but we have to express it.
Yes. Thank you for pointing that out. Yep. So when we in such case when there's concurrent jurisdiction, equity follows the law, and it's our law, and we may resort either to relief at law or in equity, then we're going to obviously choose equity because it's our law. And then we're talking about equities and law.
Right.
So I got the law part. You want to do the equities part?
Well, there's either right or there's damage. Those are the two types of equities. The statutory equity is you're seeking damage. You're seeking damages, some kind of remedy in monetary terms.
Yeah, some kind of award in the public, which if
right.
If public
some kind of public privilege or something.
Yeah, an award in the public is going to be from the negative side of the ledger, so it's going to have to be FRNs.
Right, it's going to have to be FRNs. But the only thing we can seek in the private side in equity is a right to some performance. And the only thing that the court in equity will do is compel that performance. So those are the two equities. What are the two laws? Well, they have what they call law, which is statutes and regulations that deal with damages, UCC, for instance. And then we have our law form, which deals with unalienable right, which means that it can't be taken, so it's something that that is ours to begin with, and we take that into the in-camera proceeding, and that's where we get our right fulfilled. We get it.
We get our decree. We get a declaratory relief.
Yeah, we get our declaratory relief. So we just choose which side we want to go down.
And that's perfectly consistent, Jeff, with and he may seek relief either at law or in equity. That's perfectly consistent with that.
I guess we would have to determine whether those are equal equities, though.
Well,
or damages and rights equal equities.
Well, actually, at law, is it really an equity at law?
Yeah, they have equity in the public.
But you know what? If it's public, it's fictional, so it's not really equity.
Oh, it's equity. They have equity decisions all the time. That's what the U.S. Supreme Court does. Really, is equity.
But realize
that it's their equity, their public policy equity.
Exactly. So it's not really equity. It's statutes and codes again. It's
right.
to apply to those who have liabilities, not those who have rights.
But they will call it equity.
Right. Which is really nothing more than statutes and codes, as Christian has said many times.
So here's a case where CJS is talking about equity, and we really have to analyze it and tear it apart and determine what the maxim is really saying.
What page on, Jeff?
I just found I have a list of all the equities here, and I saw that one, and I don't think it's one of them that's in CJS.
Okay.
It's from another equity book. Equal equities, the law will prevail. The ones that are in book 30A, it's not all of them. It's the primary ones, but it's not all the equitable maxims.
Okay.
So I always hunt around for corollaries. Actually, I should tell you on my list, the first one is equity regarding what ought to be done. That's the first one. We were talking about it earlier about it as it being the foundation.
And that's perfectly consistent with what Christian has said on many times, that the onus probandi switches to the trustee, that the court regards the trustee as guilty the moment they walk in once we file our counterclaim, because the court's going to presume that the duty should have already been done.
That's right.
So that which ought to be done, equity regards is already done.
As soon as they see your record, they know that it happened the moment that you delivered it.
Yes, exactly. So that's perfectly consistent with that, Max. So in sharing this information that I was out of CJS, as far as relief either compelled to resort to his legal remedy, and he may seek relief either at law or in equity, really the more we talk about it, the more of these maxims are just, it's so easy to apply them. And what I'm after sharing with everybody tonight, as people read in Gilbert's, read in any cases they might be going over, anything out of CJS, start looking at it through the eyes of the equitable maxims, because really that's what we're dealing with when we're dealing with our brothers and our sisters and our friends and our family. We're really dealing in relations with everyone, and why wouldn't we treat everybody fairly or equitably? And why wouldn't all these equitable maxims apply in everything we do all the time? Because we're simply interacting with real people and not fictions. So as we read through these, hopefully everyone will be getting a set of eyes to look at their life through the equitable maxims, so they'll better live it, and the better they live it, the more they'll own it. And that way, if they ever do find themselves in a court arguing their case, that they will do it more tenaciously, with more confidence, as Graves says in jurisdictionary. So you will better be able to prove your point, and better be able to get into the private, and better be able to extinguish the debt which this record in the public has been created against you, or I should say against your straw man or your fiction. And as we read through and talk about and discuss these maxims, start thinking about your life and how these apply everywhere all the time, because it's really impossible to live without them. And that's why I'm just trying to bring out more for everybody to understand it more and more and more, so you can see the code, as Christian talks about, and when Neo's standing in the hallway and he puts his hand up and stops the bullets, and then the whole picture turns to code instead of the agents, and he can actually see what's going on. And that's when that moment happens where you just see things through a different set of eyes. And I know for the new people it's hard to do that, and I know it's not going to come easy, but I'm going to emphasize again, go back to the recordings, get working knowledge of the material in order for you to be able to break things down. The more you can break it down, the better you're going to be able to see it, the better you're going to be able to take these maxims and apply them everywhere. Do you see other maxims that apply within the context we were talking about, Jeff? How about regard substance rather than form? Because I'm going to go to a little.
Well, I say, yeah, if you say the substance is the real, the right, and the form is the fiction, which they're using, then obviously when you bring up a right rather than a damage, then you're talking about a substance rather than a form.
Yeah, let's talk about it between you and me. Jeff, I hand you a glass of water. Does the form of me handing you that glass of water really matter for you to hand it back to me when I really need a drink? Or does the fact that you hand me back the substance of the water that I gave you matter more than the form?
Can you put that in English? Yeah, I know what you're saying. Yeah, right. The substance is what is important.
Right. It doesn't matter whether I hand it to you in a glass or whether I hand it to you in a plastic bag.
Oh, yeah, right.
Okay.
It's the idea that what was transferred and what you're asking to have come back.
Exactly. Is that glass of water, because now I'm in the desert and I'm dying of thirst, and without it I'll die, for example. I didn't give you a glass of water. I didn't give you a glass of water to hand me back a pretty diamond, even though diamonds and girls love diamonds. That doesn't do me any good when I'm dying of thirst in the desert. I need the water. So equity regards form over or substance over form. So and I'm going to back into some of the text I read a minute ago where it applies in the text we were talking about. The jurisdiction of a court of equity is sometimes concurrent with that of a court of law, and sometimes auxiliary to it. Wherever equity jurisdiction has once established and a remedy at law is subsequent created or made effective, and whenever a class is of a case is of a class cognizable in equity. Okay? Class cognizable is the thing I'm trying to point out here. But the circumstances render a legal remedy available in a particular case. The jurisdiction of law and equity is concurrent. In such case, plaintiff is not compelled to resort to his legal remedy. He may seek relief either at law or in equity. Well, the class cognizable, well, we're talking about a special class is really what we're talking about when we apply the doctrine of NTT.
Right. It's only cognizable.
Right. And that special class being a class of substance, not a class of form. A class of the real man, not a class of the fictional form.
Right. And only cognizable in the private.
Yes, yes. So when we take that maxim of if equity regards substance rather than form,
right.
do you think that we have a perfect application of that maxim?
Yeah, well, your substantive right is what's found in camera hearing. That's what you're seeking. The form of your right, see, we were talking earlier about, they were talking about rights, and those rights are the forms. Those are the rights that are given to you through statutes and regulations as a gift, as a privilege, but they have no substance.
Yeah, because they only regard the fiction.
That's right. So substance or substantive right is what we're seeking in the private side of a court of equity. So that's your substance over form right there. So all you have to do really is express your intent as the grantor of a trust that you want substantive right cognized in a private side of a court of equity. You really shouldn't have to say any more than that, because you've broken up the at-law side by saying, look, the remedy or the relief is not over there. It can only be cognized, and I can only get it over there in the private side. Just say it 3 times.
Why don't you tell everybody about the three strike rule, Jeff? Just since you brought it up.
The 3 strike rule? Oh, you mean how you say things 3 times?
Uh-huh.
I think it has. Doesn't it have a biblical foundation?
You know, I don't know that, but if we think about our notarial presentments, first we send a presentment, then we send an opportunity to cure, and then we send a default. So it's the same premise when we say something 3 times in court.
Yeah, but that notarial protest is also a statutory procedure. It can be both.
It can be both. It can be both statutory and private.
Yeah. I think it comes out of a biblical orientation as opposed to a. You remember the common law itself comes out of that too. So the basis of common law, the basis of equity, and the basis of all these maxims really have their origin deeper in the historical set, which would be biblical.
Yes, thank you. I'm glad you brought that up. And for those who are looking for that biblical foundation, please go back to some of the previous Monday night calls where we discussed Blackstone's commentaries on equity jurisprudence. Well, I think it was Blackstone's, but it was on the lownang.com website, and we had quite a discussion about that. So if anybody wants to go through the historical foundations of where the maxims come from and equity jurisprudence,
that was the law of nature and nature's God.
Yes, sir. Yep, and the website is LowNang. It's an acronym for it.
Yeah, right. That's out of the Declaration of Independence.
Yes, exactly. That statement.
Not out of Blackstone's. Blackstone's doesn't like the Declaration of Independence.
Well, but the statement of law of nature and nature's God is out of the Declaration of Independence. But the website that it's on, the equity jurisprudence.
Yeah, they tie that in. Yeah.
Right. So, and there's more than Blackstone's commentaries on there. There's other work on there just for everybody's information. Please review it. It's got some excellent information on there and some great history and everything else. That the more, and by the way, the stronger people are in history in this realm, the more tenaciously they're going to argue in their case, because they're going to know exactly where everything came from. They're not going to be doing this without roots, so they can just blow in the wind. They're going to be firmly anchored in their beliefs and where things came from. And I think that's critical to being a person who traverses into the outlaw realm to get into private. I think it's critical for a person to be tenacious in this from that foundation. I'm looking at equity, imputes an intent to fulfill an obligation. This is a Section 124 in CJS. It's a maxim, and I'm trying to figure out whether or not this maxim applies in the context that we were talking about in the class cognizable inequity, but the circumstances render a remedy available in the particular case in the jurisdiction of law, and equity is concurrent. So I got to read this maxim because I haven't read it yet, and I'll share it with everybody. It has been stated as a maxim that equity imputes an intention to fulfill an obligation. Another maxim of equity is that equity imputes an intention to fulfill an obligation. This means that where an obligation rests on one to perform an act, and he attains the means of performing it, it will be presumed to intend to perform through such means, and usually will not be permitted to show the contrary, equity giving the effect of the presumed intent. The maxim has been applied in connection with the maxim discussed Super 121, that equity regards as done which ought to be done. Okay, well then yes, this is consistent with our class cognizable case, that the equitable jurisdiction could be applied for the trustee having for the duty imputed upon the trustee.
Right. Well, in what we're talking about, you're making a choice. So if you're going to make the choice of equity in the private side of the court, what are you really trying to choose?
Performance.
It's only performance. That's all that you want.
Now, Jeff, we could continue with applying the maxims towards this couple paragraphs that I read, because I think it's a great application. But I just want to make sure that if there's anything, because it's 11:40, we've been talking for about a little more than an hour and a half. If there's anything you wanted to bring up on the call this evening, I don't want to let too much more time go by before, if there's something you specifically wanted to bring up, I wanted to give you that chance to do that if you've got something you want to bring out tonight.
Not really. I was going to go along with what you were going to present. I thought we were going to get into the 121 section, but we have time next week.
Well, that's fine. How about this? I'll just we'll apply the maxims to the next paragraph, and then I think we're going to be able to get into 121. I just wanted to make sure in case anything you had was going to take a while, and so we don't have too many people drop off and have to go to work.
I think we should get into some questions.
All right. Let's see if anybody wants to do that, and if anybody wants to add anything to the call. Lisa, if you'll allow people.
Q&A session started.
Eric?
Please press *6, then 1, in order to get in the queue line to ask a question, and then state your name and where you're from. And please relate your statements this evening to the context of what we've been talking about, to the maxims. And then, can we learn from whatever it is you're asking, but everybody else can. And then if you have a specific situation, let's try and apply what we're learning and teaching in the maxims to a specific situation. Of course, if you have anything specific, please keep it hypothetical for everybody, including us, that's listening. So again, *6, then press 1 to get in the queue line. Jeff, until we have somebody come in and interrupt us, we'll just continue where we were going.
That's good.
All right. And by the way, if anybody comes on the call, just interrupt us at any time and let us know you're there. And then if we have a point to finish, we'll go back to finishing it. If not, we might take a break and just go ahead and take you right then. And if you are on the call and you come on with us, and if we go back into talking about something, if there's any background noise, please mute out on your end if you want to continue to have discussion with us, so we can get the call clear for the recording for the future and for everybody else on the call this evening.
Hey, can I break in?
Hey, Darren. Good evening.
Hey, how you doing? Jeff, wow, what a surprise. Good to hear you. I wanted to give you thanks, and Jeff has really helped me understand NTT. He was very patient with me, and it took a big sledgehammer, but I tell you, he was very patient in working with me to understand NTT. It wasn't a gradual, it wasn't an easy conversion either. But I just wanted to give him.
You converted?
Yes, I'm converted.
Okay.
I've seen the light.
That's what I want to hear.
Yeah. I had an interesting question. I was just thinking of this today because I was on a call last night on Mel's Bar and Grill, and we were talking about some of the administrative courts, and there was an interesting an interesting view. I haven't had any time to research it, but what they were saying was basically that's really the original jurisdiction for any matter which is contained within the county, regardless of the situation, whether foreclosure or anything. But anyway, what my question was, I'm not sure if anybody really knows the answer, but let's just throw it out there and see what happens. I wonder, can you do an action in equity in an administrative court? I mean, because we were dealing with legislative courts anyway.
Court of equity, if it recognizes a court of equity, then you can do it. But I kind of doubt it. That court deals with privileges.
It was just a pondering thought I had.
Yeah, you can get where if equity exists in that building, you can invoke it.
Yes, and that's the key word, invoke.
Equity
You have to invoke.
That judge's mind. If
Right.
it's in his mind and he knows equity, you can invoke it.
You see, but the only problem is something what you mentioned earlier, Jeff, is that you're dealing on the lower levels too.
Right.
Lower levels, they really don't have the recognition of equity as they do with the upper legislative and federal courts.
Right.
You know, that's the only.
That's where we have to go. And I wouldn't deal with an administrative court myself.
Right. It was just a thought that I had. I was just wondering.
I know it's been talked about a lot, but first of all, those administrative courts deal with the privileges that the fiction creates for us, and then you're arguing whether you are allowed to have the privilege.
Well, actually, because in an administrative court and how a lot of these various agencies where they have really, and the reason is because people have slept on their rights, is because in any action where you're being, let's say, attacked by whether a state or federal agency, then it runs under the Administrative Procedure Act. And if you really read the act, you as a private person and not as a state agency, that act only applies to them, and you can only come in as either the plaintiff or the let's see, there's the word, either the plaintiff or the petitioner. You can never come into as a defendant or a respondent, which is typical. That's typical with a RAM type hearing. But the thing is, because you don't rebut that, then you accept it. You know, and that's a lot of things we've been talking about with a lot of the courts. Is anything that's brought up is that you have to object to it, or else you're deemed to accept it.
Right.
But that was just one point on the APA, which is under 5 USC, as well as
Hey,
even under 4 countries. Yeah.
Let's look at it like this. If you're going to allow them to presume you're a fiction, then you have no voice. Because equity is written on the judge's heart. There's no excuse for him not to recognize you as a real man once the records exist and you have the right pleadings in order to get into the private.
I don't think it's about that. I think it's more of the ignorance, and I'm not saying that in a bad way, just the lack of knowledge on the lower courts, especially an administrative judge on the lower side that actually understands equity versus, let's say, a federal court up on the higher levels. They have a better understanding of equity. And I'll give
Darren, you know what? When you prepare your cases from the beginning to go to the appellate level and supreme levels, they're going to see that in your cases. There's no excuse.
Yeah, and just like even like we were talking about before, you know, the way to basically act in a courtroom, and it's just like what I sent CW and his wife was actually some court cases, so you actually see how the judges respond and how, just like in that one foreclosure case, which was a real good case, but you can even see that the judges are kind of like saying, well, teach me or instruct me. It's almost like you almost have to instruct them in certain things.
Well, you know, that's what the appellate and supreme levels are there to do, is to teach them and instruct them. That's why we prepare our cases to go to the next level.
Understand that.
But the premise of your question was, I wonder how this would work in an administrative case.
Yes.
Well, if you give them the authority to push them towards the right direction, in other words, take them to the woodshed, because that's exactly where they're getting taken to if they decide to act outside of what the next higher level up is going to force them to do, then let them know from the beginning that's where they're going, to the woodshed. They're going to get that case is coming back to them, and they're going to be forced to make the right decision, just like you do when you're a little kid. There's no excuse.
Right, but it's just a pondering thought. It was just something to think about, because really, once you're invoking equity, you can really invoke it in any court, for considering that it can hear equity. That it's permitted.
I think that's been kind of an elusive thing. I think that some people go, well, that's not a court of equity. Well, I don't see how any court is not a court of equity.
Well, once again, just like you were talking about with that one guy that was in the bankruptcy court, I don't think a bankruptcy court is a court of equity. I think that has to be remanded to a district court.
Well, we've been talking about recently that whenever we do our case, or we prepare our case, we're to prepare it for the appellate level. And so if we do that, we will be invoking a court of equity, even though we don't think of it that way.
Okay, but here's the problem. Here's the problem that you run into if you don't do your homework first and find out if that court can hear equity, and you go ahead and proceed. Then the first thing they're going to do, they're going to dismiss it for lack of jurisdiction.
Well, but then you can remand it to the higher court. You can have
right, but I'm saying just to save the legwork, if you would to know up front that they can't hear it, you might as well go right to the upper court to begin with, and don't waste time spinning your wheels. You see what I mean?
But let's look
well,
at
if we could do that, that would be okay. But sometimes you can't do that.
But that's where you find out, because of the matter that you're invoking, and if they're prohibited to hearing it in one court, then you have to go to the next court. And that would invoke the jurisdiction of that court, because you don't have a lower state remedy to proceed if that lower state remedy cannot hear equity. So you have to go to the upper court. In other words, that's the only open door you're going in.
Well, that's really what tonight's call is really about, is the either remedy at law or what we got to do to determine that there's not an adequate remedy at law. That's really the heart of what tonight's call is really about, whether we're in a court that can hear equity or whether we got to find one that can hear equity. I think that's consistent with what
that's more jurisdiction. That's a jurisdiction question. That's a jurisdiction.
Derek, I think that's consistent with what we're talking about. So whether we can find our relief in equity opposed to being a general depositor and making letting the court presume, as they like to do, that we're in the right realm. So as being one who applies the doctrine of NTT and recognizing that there is no adequate remedy at law, then it's part of our duty to determine that the court that we're in is a court of equity. I think that is consistent with
right. Well, the thing, because the thing is, when you're in a court that can hear, that's basically split in the dual sense of the at law and the equity side, which we're invoking the equity side. We have to be sure that we're in a court that can hear that equity side, because if we're not, it's not a matter of there's no adequate remedy at law. The matter is that the court can't hear it. Now that becomes a jurisdictional matter, not a remedy at law matter.
All right.
Okay?
I'm with you. So let's take some of the maxims that we talked about and figure out how they apply to what you're talking about.
None of it would apply if they can't hear equity in that court, because they don't have the jurisdiction to hear it.
Wait a minute. I understand what you're saying, but let's take what you're talking about and let's bring it into the context of why we're on this call this evening, and that's to discuss the maxims and apply the maxims towards the context of what we're talking about for practical application, so we can better understand the maxims. Let's stay focused on the purpose for the call, Darren.
So what we're saying, what you're saying is we're assuming that we're in the right court that can hear equity.
Yeah, that's the reason when I first announced that we're taking questions and answers, I announced, please keep your questions and comments in the context of what it is that we're talking about this evening. Okay. So if you're going to bring this up, then you got to bring it around to what we're talking about this evening, and that's the maxims. And
Darren, it's actually the reverse. You're a man walking in equity. You're a man walking around living equity. You are equity. You want to see if that court can hear you. It's not whether the court has equity or the court can find it somewhere. You come in and you say, I am equity.
Right, exactly.
So
Yeah.
if they immediately say, I have no idea what you're talking about, then your next response is then I need to go to the highest court and have them direct me to that court of equity so that I can get my remedy or my relief.
Right.
And if truly do have a court of equity, then he's going to be squirming a little bit because he just lied to you.
Right, but that goes under the liar, liar, pants on fire doctrine.
Yeah, but that doctrine is easily solved by just you standing in equity.
Absolutely.
And worry about where the court of equity is.
See, we've always said before that we're trying to pull them into our jurisdiction, and our jurisdiction is private, and that's equity.
Absolutely, but we go back and like even Eric was talking about the history is knowing about the history. Well, the history of the courts was prior to there used to be two separate courts, and then probably from an administrative standpoint is that they merged them together, and the problem is because of our own ignorance is that we all went in through the wrong door. We all went in through the at-law door all the time rather than going in through the right door.
Hey, Darren, what kind of court is an administrative court? It's a
I'm
court
sorry?
What kind of court is an administrative court?
Right.
It's a court of for process and procedure.
That's true.
All right? So, you were pondering the question. What was your question originally on this?
Can they hear an equity issue in an administrative court?
Well, considering that it's a court of for process and procedure of the way things are administrated,
yeah, but
you're going to have to figure out how to stop the administrative set of procedures and get out of that realm, even though you might be standing in the same courtroom, and invoke your own law form.
Jeff said it very clearly. You have to invoke it. That's how you determine the law that's going to be heard in that matter. But my question, mine is stemming from this: if they cannot, by their own duties and performance, cannot hear any issues. Let's say that we are just an administrative court. This is how we are set up. This is how we were always set up. We can't hear any issues in equity. Then you're in the wrong court. So it doesn't matter what you do there. You know what I'm saying? And it's not based on what we think, and really that just has to be homework on knowing what the court can do and what it can't do even prior to even going in there. And you can't do it based on an assumption.
Why would you even bother take something into one of those courts, Darren?
I'm sorry?
If you're doing NTT, why would you even take it in there?
Well, if you're invoking equity, what would the matter be? Because the administrative courts, let's say if you have a issue with a state agency or state employee, that's who that administrative court is.
Just create a trust and take it into a state court.
I think what Darren is pointing out could be a good point, though, in traffic court, for example, because that is an administrative court.
Great point. I'm sorry, go ahead, finish, and I got to make a comment. You just hit a nail on the head. I want to mention something.
Well, I was just going to say that I went into traffic court, and I didn't get my relief. Of course, I was ignorant in what I was doing at the time, basically, compared to what we understand and know now. But had I known at the time, I would have gone into the court, and I would have made that court allow me to remand my case to a higher court, because that court cannot hear equity. And so if I would have known that at the time and would have known what to do, it would have saved a lot of time.
Right, and that's the point, because it couldn't hear it. So it was already handcuffed. It didn't have the jurisdiction to hear that side regarding equity. And that's another point, is just like even in realize that you have never seen a truck driver in a traffic court, and the reason is because they have a totally separate court than what regular people do that drive vehicles do. They have their own administrative court that hears any matters involving how they're operating.
Well, yeah, because they're operating in commerce. You're not, as a private individual.
And there's administrative rules that apply in commerce.
Right. I'm just making a point. I'm just thinking outside the box because really, in an administrative court, because your grievance could be against a state agent or state agency, which is really going against them because we're coming in as either the plaintiff or the petitioner, so that gives us the upper hand right off the bat. Okay. Now we're bringing in equity, and we're still coming in there, which makes it even stronger. And of course, if we're naming them as they've been acting as a trustee in some type of dealing, they're already guilty now that they're in equity. So they're kind of like double guilty.
Yep, double guilty. I like that.
Yeah, double guilty. That's right. Double fucker, as that movie said.
So that means we get double relief.
Yes. When we pass go, we get $200.
All right. So what else do you have that relates to to the context of what we're talking about tonight, Darren?
That's it. I'm done.
All right. If you come up with something else, please feel free to share again. If anybody else is on the call, please state your name, where you're from. Press *6, then 1 to get in the line, and let's see if we can keep it in relation to what we're talking about, or at least bring it back to it one way or another.
Hey, can you hear me?
Yes, sir. Who is this?
This is Albert.
Hey, Albert.
Hey, Darren. How you guys doing, man? Did you guys tell everybody about you have to be a qualified person to go into equity? You know, the class of person that you must be?
What is it you mean by that exactly, Albert?
Well, there's two classes of persons that equity sees, but they only hear one. You know, do you remember that one?
Well, why don't you just go ahead and bring us to the point. What classes are you talking about?
I was going to let you guys teach it, but anyway, special deposit. That's the only thing they'll hear. Trust
in equity.
Special deposit.
You're saying that's only in equity, right?
Yeah.
Okay.
It's only in equity. In fact, I think Floyd read it a few months ago or so.
Yeah, you want to take all the general deposits and convert them into special deposit them as special deposit, and you're in equity.
Yeah, that's the foundational doctrine of NTT. Thanks for bringing that up, Albert. That is good. So
that's all I have.
Oh, I thought that was your premise to bring up a point. Okay.
He was trying to put it out of us.
You fly with it.
Pardon?
You fly with it.
Well, it's something we continue to weave all through what we talk about all the time is the withdrawal and the redeposit. So when I'm talking about, for example, in what I was reading earlier, the class cognizable, that was exactly what we're talking about, is doing a withdrawal and a redeposit for the class cognizable to be heard by equity, where we might have the opportunity to go either at law or in equity.
Right.
So
in the same court was your at law case, if necessary. I understand where Darren was coming from, and Floyd got to the point. What if you get a ticket and you go to the rinky-dink courthouse right down the street from you? Well, you're going to have to learn how to get your case remanded. Learn the verbiage, get remanded to a higher court, or maybe somewhere through a special deposit they remand you automatically. I don't know. I haven't gone that.
That's a good point. That's a really good point, that they might remand you automatically based on the facts that you present. But, come to think of it, from something I said earlier kind of occurred to me. The local courts are primarily designed for general depositors, those who don't qualify their grants. And I'm sure a lot of the appellate level and supreme level cases see most of their cases that way as well, unfortunately. But that doesn't mean that occasional person, very occasional person, for example, those of us here at NTT, doesn't come along, and they've just been waiting for us. But that doesn't mean that when we go into that local court, they don't know what it is. It doesn't mean that they can't recognize it. It just means that maybe they're just used to doing what they've been doing for so long, so consistently, that it would be like the talking dog, and the dog isn't saying hello, I love you. It's actually quoting Shakespeare. This would be a very unique situation, is really what I'm trying to communicate. So maybe it's not that it's a rinky-dink courthouse. Maybe it's that we are just so used to, or they are just so used to watching the dogs eat the vomit, for reference to what Christian says about the people who continue to operate in commerce and continue to take and take. They're so used to that perhaps we are class cognizable that's so rare that until we are absolutely strong in our foundation and tenacious about what it is that we're venturing into, that we're going to presume that they're going to treat us as they are a rinky-dink courthouse, where it was really our fault. It was our duty to go in there and properly present the facts and argue tenaciously enough to get our point across that this is not a general relation. This is a private special relation, and this is not the forum in which to discuss this. And it takes a lot of study, a lot of involvement, a lot of faith in order to be able to do that. And for those who are new, you're not going to get it by listening to a few recordings. You're only going to get it by being consistent about this and getting and finding a working knowledge and reading cases and listening to us talk about cases that we read. So perhaps it's our fault for slumbering on our rights all this time. Do you have anything else you want to add, Albert?
Well, just for the record, I haven't slumbered. You can ask my mama.
Well, I wasn't suggesting anything about anybody specific, Albert.
I was just joking.
Oh.
Anyway, you guys are doing a great job. Keep going. I just wanted to bring out the classes of persons and see if you wanted to talk about it to the folks. That's all.
Thank you, Albert. Well, I think that the class cognizable that we talked about earlier is specifically what Albert's talking about, everybody. So if when you go back and listen to the recording, keep that in mind, so you're aware how a person does get recognized, or I should say a real man does get recognized in equity.
You guys really talk about it really good on 1129. I just thought I'd say that for anybody who wants to download that call, 1129. You guys talk about it real well.
Thank you, Albert. That was that a Monday?
Yeah, that was an ambassador's call, yeah.
Okay.
Thanks.
And again, go back and download the 529 call, because Christian he reads further in the remedy at law. Now that we've been talking about it tonight, when you go and listen to tonight's call again and then go back and listen to that, you're going to have a much better understanding about what he's talking about in CJS as well, that we reviewed so far this evening. If anybody else has anything that they want to share, please press *6, then 1, and then state your name and where you're from. All right. No one else is in the queue at the moment.
Okay, you brought up you did bring up something when you were talking to Albert that I wanted to kind of expound on just a little bit, and that is that you stated that it's our fault that the courts are doing what they're doing, and I totally agree with that. And the thing that I think we need to recall or remember is that we need to realize who we are. I don't think we remember who we are most of the time, that we are a real man with real rights, that we have all the rights that were given to us by God, not by man, because only man can give us privileges, and that when we go into the court system, we have to remember that we are private. And I think that that's something that we need to continually rehearse in our mind until it becomes second nature to us. And that's something I think that we need to keep telling ourselves.
Yeah, Floyd, I guess really another way to say it would be, let's stop being infants and let's be men. Let's act in a way where we can show that we have in fact reached the age of majority. That we don't need a guardian because we're not a warrior.
We keep acting like we're slaves. We have the slave mentality instead of the Lord mentality, and we need to understand that we are the Lord. We are not the slave, and this is why when Jeff pointed out earlier that when you were talking about the courts giving the decision as to which side of the court you're going to go into, the statute side, the equity side, it's not the court that determines that. It's we that determine that.
That's so true, because that court can't move unless we move it, Floyd.
Well, the only way that we can move that court and remember that and cause that court to move is by remembering who we are.
Remembering and knowing.
That's right.
Yes, sir. And for a lot of the people that might be new to the call, I know it's a daunting thought to consider that you could actually move the court. But
now,
it's possible.
Okay, now when we say that, or when we talk about being remembering who we are and knowing who we are, doesn't mean that we go into the court with an attitude of superiority and a pugnacious attitude. In other words, we're not going in there to do battle. We're going in there in a humble, peaceful attitude. And when you have the power to do what you can do and have to do, you do not need to act like a patriotia and exert your rights. You need to state your rights, but you don't need to exert your rights in the point of you become that you start saying stupid things, and I've seen that so often.
Well, that brings up a good point, because as soon as you start shooting your mouth off about things that are irrelevant or that don't apply or that might be disrespectful to the court, at that moment you might reach, you might commingle, and you might not even realize it. Stick to the four corners of your pleading.
Exactly.
Let's not, and I think that is absolutely again foundational to anybody going into court. Don't go in there thinking you're going to argue their points, because that's exactly what the other side wants you to do, is to get you off your game, to get you thinking how they want you to think. So you're defensive. You are not going in there to be defensive. You're going in there to make a claim and provide the evidence that you have rights, and so you can get into the private in order to get specific declaratory relief that a trust exists, and then a dismissal of their action so you can go into the private, so then you can go ahead and get the performance that you have the right to get. And in this situation, we're talking about the extinguishment of debt by applying your equitable asset. And of course, this is in the civil realm. So to again emphasize what Floyd is saying, stick to what's in your pleading. There's no reason to bring anything else up. You're going to be viewed very quickly as somebody who doesn't belong there, and they're going to put you right back under statutes and codes. And no matter how much work you did to try to get into the private, they're going to deem that you're not sent here. You're not conducting yourselves with knowledge and understanding. And to add to that, none of us can do this with a simple form that we carry into court that somebody else created. This only comes from owning the knowledge and being able to apply it, because you will be tested. So for anybody on this call thinking it's that simple, we're here to tell you that it's not. You got to put the hours in, you got to put the time in, you got to gain the foundational understanding, because only a king has the knowledge to be a king. So if that's who you want to become, well, we're here. We'll be happy to share things with you. Please come on the call and discuss things with us so we can share more with you, and we can even learn from you. But lately, we only have just a few people coming on the calls. So if more people would come on, maybe the more people could gain a working knowledge of NTT.
Yeah, if anybody out there really has a question and you think that it sounds ridiculous to ask it, don't feel that way. The only way that we learn is if we really have an honest question that we don't know the answer to. If we ask it and get that answer, all of the pieces will fall into place. If you're holding back because you think that we're going to criticize you for asking a stupid question, please don't feel that way.
Yeah, we're not here to be critical of you. We might test you. We might push you towards some things you don't know, but that's just to make you realize what you don't know, because the judge is going to do the same thing. And we want to motivate you to dive into the information, because we're not going to be there when you're standing in court. And we want you to be able to stand strong on your own as somebody who doesn't need a guardian is able to do. So that's our motivation for anybody that listens to these calls or is thinking about asking a question. So again, *6 to unmute, then 1, and we'll be happy to chat with you and share whatever we got. Jeff, do you want to go into 121, section 121?
I think it needs a good hour and a half presentation for that. I think it's a real strong lesson.
Well, I'm good for another hour and a half if you guys are.
Well, I have to get up. I have to get up early in the morning, and so I can't really stay on real late tonight.
Okay.
So personally, I would rather do this when we're fresh and can contribute the total concentration that it really deserves. And that's me. You guys can do whatever you want.
Well, I would stay on if we had a lot of questions, but if there's no one in the queue, then I think I would suggest next Monday doing it.
Whatever works for you guys.
Hello. Anybody in the queue?
Hey guys, I'm here.
Okay.
Somebody. Hey, this is Dan.
Hey Dan, good evening.
Hey buddy. Hey, I came in kind of late, so I have no idea what the call is about tonight. And I know you want your questions geared towards that. So if you could fill me in real fast, it'd be awesome.
Well, if you want to ask a question, we'll find a way to bring back the subject matter to your question.
Fantastic. Okay. I just got word today that even though I've been corresponding with the trustee, well, I've been sending correspondence and never getting anything back.
Hey Dan, you got to keep it hypothetical, my friend, for the purpose of the call.
Yes. Hypothetically, there was a letter received today that is in piece of property, piece of land that I have. So I was wondering how can I effectively get that into court, because this is a state where you don't go to court. Or am I being too general?
So you're in California.
What kind of paper was it?
It's a paper that states that they're going to sell they're hypothetically going to sell a piece of property that I own without taking it to court first.
Is that an offer for a general deposit?
See, I've already done the withdrawal and the redeposit. Steve we given him the opportunity.
Who sent you the letter?
It was actually from a different corporation. It was from Pacific Northwest title of the state.
It's a different offer, and it's a new offer, and it has to be responded to.
Oh, yeah, that's right. I knew that. So essentially, I need to go in, do another withdrawal and redeposit, completely treat this completely as a separate case.
It's another trust.
Okay.
And then, if the trustee does not perform, then you have the option of going into equity to compel him to perform, which means that you go into court.
But until you tell that trustee they got res, you can't impose any duty on him.
Right. You've got to prove that you have all the elements of a trust and that you transfer the res.
Okay, well, that'll be simple. As long as
was that the nature of your question, Jeff? I mean, Dan?
Say that again, bud? Was
that the nature of your question to get at that, to what to do with the letter?
Yes, that was the nature of my question. Well, no. Okay, now once the trust is formed and everything, how can a person bring this into court? What does an individual have to do to be able to bring this into a court in a deed of trust state if they don't go to court?
Say that again, a little bit slower. What is what?
In a deed of trust state, what's the first thing an individual should file to get this matter into a court?
That's all that law, that deed of trust stuff. You're dealing with equity. You're dealing with the trust, right?
Yes, but once I get there...
Okay, so you're going to deal with it as a trust. It's going to be breach of trust if the trustee doesn't perform.
Okay.
Doesn't matter, it doesn't matter about the outlaw side and what they're thinking and what their rules are. You have a trust, and the trustee did not perform.
I agree with that. I understand.
So there's a reason why you can be prevented from instituting an action. Doesn't matter what the deed of trust state says.
Hey, I agree with that. But
hey, Dan,
I need to know what's that.
Christian offered something. in your situation, he said, because the trust has already been formed with the party you've dealt with previously, right?
Yes.
All right, and they got proper notice, right?
Yes.
All right. Well, he said, nope, you just need to give this new party a notice of the previous withdrawal and redeposit, notice him of a breach of trust, and because he is trespassing on the trust, then go into court and get an injunction.
Okay, so essentially I want to treat this new fiction the same way I would treat it in court. I don't want to give him the private information. I want to give him general information about the trust, but also notice him, and then if he continues to trespass, that he's going to be in breach.
Yeah, and it would be very smart to give him general information, because if you give him private information, he might try and, or this new trustee might try to expose your private and commingle, and then you'll have a breach claim against them. Christian said, treat him as a claim jumper or a trespasser. That's exactly what I was thinking about. Sounds like there's no real party in interest here when you were first starting. When you first brought it up, it sounds like there's nothing saying that this party actually has an interest.
Yeah, pretty much. If they did have an interest, they sold it. So.
Okay.
Okay.
Yeah,
that makes sense.
All right. So let's take the maxims. We were talking about the maxims, and we were doing some practical application, and we were talking about how they might apply, and we could shoot a couple of them off since Dan brought us up a good situation, guys. Which one do you think we can apply here, guys?
He who does equity he who seeks equity must do equity. I have to make sure my P's and Q's are covered first before I go after them.
Got it.
And equity will not allow a trust to fail for lack of a trustee.
Equity will not allow a wrong to be.
Not going to have a on this one if you go along with what CW proposed.
Equity regards substance rather than form. Equity regards that which that is done, which ought to be done.
Yeah, he's already got a trust.
And Jeff, realize this, that you have the superior claim here. Dan, you realize you have the superior claim. I apologize. You're not Jeff. I apologize.
Oh, I do absolutely have the superior claim.
You do?
Yes, that's what I'm saying. I do. Absolutely.
Yeah,
and now he's trying to trespass upon a private matter, and
all they have is a legal claim. You have an equitable claim, so you have the superior claim.
Yes.
And let's look at equal equity in this situation, guys. It's been frequently stated as between equal equities, the law will prevail. This maxim is as old as equity jurisprudence and is closely connected with the maxim in 127 that where equities are equal, the first in order of time will prevail. In accordance with the maxim, a contrast between a legal and equitable title to the same subject matter, the legal title in general prevails. This rule is frequently enforced by supporting the legal title to land as against an equitable title, an equitable right no stronger than that of the legal owner. The rule is applicable to species of property other than land. The superior legal rights, short of actual title, have the same advantage. The maxim is applicable where no equity in either party, where there is no equity in either party. You hear that, Dan?
Yes, sir, I sure did.
The maxim is applicable where there is no equity in either party. So this maxim does not apply. So this is the first one where we found a maxim that didn't apply. Where the party having the legal right acquires another interest inconsistent with his equity so that he cannot honestly claim both. His priority is lost and equities will prevail in order of time. XV termini, the maxim has no application unless equities are equal. That was awesome, Dan, that you brought that up so we could find a maxim that didn't apply.
Glad to be of service.
Yeah, that really, because, you gotta look at these different situations and figure out what does and what doesn't.
So, Eric, why don't you say again to him what CW suggested? I want to hear it too.
That he said that you just need to give them a notice that the previous withdrawal and redeposit, to notice him of a breach of trust because he's trespassing on the trust, then go into court and get an injunction to stay the sale and another action against the property, and treat him as a claim jumper or a trespasser. So you got to do a bill against this party, Dan.
Okay.
So you're gonna get put together a bill in equity. All right.
Well, bill in equity with the original. They're the ones that started it.
Well, he might have to put a bill against both because this party here, if they put together an outlaw action against you, in the state you're in, Are they required to put together an outlaw action against you to perfect their lien?
In Alaska, no. Well, wait a minute.
That's what he's saying is that they're not. They can just go do it.
Yeah. And see, I'm military, so they have to take me to court. So I don't know where they get off saying just deciding to do this way.
So that's part of being in the military for everybody's knowledge, no matter what state you're in?
I guess for at least Alaska.
Okay.
My wife is telling me, yes, it is. It's that way because it's, especially, I think because of the Veterans Administration is involved in this as well. At least on the outlaw side, I don't really care who they have involved. I've got it summed up in the private, and it's already been taken care of. They're just not doing their job. So I'm going to have to enforce it.
But that goes back to us talking about having to take the child to the woodshed and having to teach them a lesson. And that's exactly what we're talking about with doing the bill in equity. You're going to have to take them to the woodshed, Dan.
Yep, a little bit of tough love here.
That's right. So what I would do, first of all, in order to have some teeth against them, is I would, first of all, get some authority based on you being in the military and that no matter where you are, they got to take you to court. And I'd first remind them of that and buy yourself some time before they just try and do a conversion, a quiet title action against you.
Yeah, I got till March 22nd, I think it said.
So
don't time pass.
Right.
Yeah.
I would definitely figure out what I got to do to force them to bring you to court first.
Right.
That would be my first thing, and then I'd be working on my bill in equity. And of course, once they make a claim, then you got to go ahead and compel discovery on them, and they're not going to be able to provide any facts. They don't have any, right?
We got a copy of the promissory note, though, Judge.
But you know what I'm saying? I mean, this is a claim jumper. They're not going to have any facts.
No, well, they do have some facts because on the Outlaw deed of trust, they were the Pacific Northwest title, I think, was the trustee. So in that sense, they have something on this, but I had hypothetically brought action against Wells Fargo because they were the ones sending me offers in the mail for me to pay them every month.
Yeah, I understand. Well, guess what? Since you have record of them being trustee, well, it sounds like they have duty.
Yeah.
That's awful convenient.
Yeah.
They held the res. Doesn't matter who they gave it to. They had it in their possession.
They breached, too.
Well, once he expresses and he gives them duty, they did. At this point, it's just a general relation.
I think looking back on it now, I think I probably should have started in my initial action with them rather than with the corporation known as Wells Fargo.
Well, you could have done your initial action with both of them and made them co-trustees.
Yeah.
And then that title company's going to look at Wells and go, you better perform. And Wells is going to look at that title company and go, you better perform. You're not getting my sensitive parts in the ringer. Because they're both going to get each other's lawyers chasing after each other going, you better do your duty.
Right.
And of course, they can't bring any, they're not, the trustees that you sign in each one of those situations ain't going to come to court, even if you order them to come to court. So you're going to win by default right there, because they can send their lawyers all they want. But you're compelling them to come, to bring the real party in interest, not the attorney.
Yes.
And I hope that's your indenture.
I am grantor, in fact, and I do hold the ability to change the information anytime I want to. I guess I could go ahead and make co-trustee.
There's a thought.
What would be the better avenue to travel, hypothetically, doing the co-trustee or doing the notice?
That's your call, my friend.
Okay. All right.
And you could notice them that they're a claim jumper. That they're a breach. They're a breach because he's trespassing on the trust. So making them a co-trustee or notice they're in breach. They both are going to have be in contempt.
Right.
Either way.
Right.
To me, I don't know. You tell me. It just depends on what you're ready to enforce. It's up to you, really. I can't tell you which direction to go. I can just suggest some of your options.
I think it'd probably be easier for me to keep this at a more simple level and just leave it the way it is, and then just let them know that they're claim jumping.
Well, that was Christian's suggestion.
Yes. Are you at liberty to forward me his suggestions so I can look back on it later?
I am.
Okay.
What else you got for us, Dan?
Honestly, my friend, I have been inventing the past couple of days, and I kind of took a step away from NTT for a bit. So I don't have anything at this point. That was the biggest thing that I just had come up, and I knew that I was hoping we could tie it in tonight, which sounds like I was able to.
Thank you for your contribution. If you think of something else that we're talking about and we're going along, please come back on.
Absolutely.
All right, thanks. We have Albert is waiting. He has something to add. Albert, are you still with us?
Dude.
Hello?
I barely heard you.
Oh, hey,
okay.
Albert.
How you guys doing? I was just going to not really ask a question, but give you something I'm thinking, and I just want to hear your guys' thoughts. But as I'm doing my bill, I was thinking to write it step by step, like making a brick wall, going up brick by brick. What do you think about that?
To make sure I understand your question properly, you're thinking about when you're creating your bill.
Yeah.
You're suggesting that you're going to put one point down and then you're going to build upon it?
Yeah, you build it up to the climate.
Well, I would think that we're going to have to start at one point and then build upon what we begin upon, if I understand your question properly.
Yeah, you got me. We do our foundation, right? That's what it's called. And we build upon the foundation, the elements, the maxims, what we have found about these maxims to put them on notice, the sites that we find, and then that would lead to the final climax, which would be the indenture.
Wait a minute. Are you suggesting that you're going to put your indenture in your bill?
No. That would be a separate paper with a declaration,
Are you suggesting that you would put your indenture in in the bill that you file?
I'm not talking about court. I'm talking about sending this to a trustee, and the indenture would be their directions after I build up from my foundation of my rights being taken, and build up on that the evidence that I have gathered.
You're just writing a trust agreement, Albert? Is that what
it would be well, no.
In the agreement, you're not trying to prove anything.
Well, we need case sites, don't we?
Hey, Albert, let me make sure I understand, because I'm kind of confused about what it is you're suggesting here. Are you talking about doing a bill in equity or an indenture?
No, a bill in equity, and the indenture would be the climax of the whole, leading up.
Albert, it sounds like you're commingling. Okay, a bill in equity is a pleading that's going to state your claim, and you're going to use evidence to support it, and you would not use an indenture to support your bill in equity.
No, the indenture would be the instructions, right?
For the bill in equity? No. That would be the instructions to the trustee for your specific performance.
Right.
Okay? The indenture is something that's private that goes to the trustee. That is not something that's going to be brought out in the public.
Okay,
as soon as you introduce your indenture into the public, you're going to commingle. You're going to breach your own trust.
No, it's not going to the public. I probably called it wrong. I should have called it memorandum in equity.
You should have called it your memorandum in equity instead of what?
Instead of bill.
Albert, I think you're confusing a couple things, and let's set a few foundations here. Are you talking about going into court or specifically interacting with the trustee? What are you talking about specifically?
This is going to a private trustee.
Okay, well then you're not going to do a bill in equity, and you're not going to do a memorandum in equity when you're interacting specifically with a private trustee. Those documents are not going to become part of that interaction. You're specifically going to do a special set of orders.
Well,
that's what you're going to do with the trustee. You're going to give that trustee orders, commands, and directives of what to do with the rest.
Did I misunderstand that we don't lay out our foundation?
That's for your bill in equity.
Yeah, I think what he means is that his foundation of where he obtains his right to even write an indenture. That's a declaration paragraph where you can state your law form. But you don't need a bill in equity or a memorandum to do that. That can be part of the indenture.
Okay.
So yes, you can lay down your foundation, and then you can present orders and instructions to the trustee as to how to perform with that trust res that you're granting to him.
You said it much better than I could. But you're right, that's exactly what I was talking about.
So that's what you just write a paragraph that establishes your form, your law form.
Yeah,
what
I did that.
we're using is the 1776 law form, which grants unalienable rights.
I was even going to use the Article 6 of the Hague International Law, where it states
the Human Rights Convention.
The Hague.
Yeah, the Human Rights Convention.
This is on trust.
Yeah, there's one on trust too.
Yeah, that's the one I'm talking about.
Right, you can do that, but I think you should have a more fundamental source. The best source is the Declaration of Independence, and then you can build on that through the Hague.
Okay. Well, I appreciate it. I mean, you guys fortified what I thought I knew.
So just to make sure that we understand exactly what it is that you're talking about, just to separate the two, you were specifically talking about interacting privately with the trustee and not traversing through the public side of the court to get into the private, just to make sure that's what the nature of why you came on was this time. Just to be sure about that, so we can not only help you but help everybody understand the difference between those two things.
This was all a private question.
So this was all specifically in order to how you might. I guess really the nature of your question was, how would I write an indenture? Where would I start? And what would I do next? Is that really what you were getting at?
No, I had an idea that I got from the calls that you build a foundation, your elements, method, your law form, and you build from your foundation like you're building a brick wall. That's all, and leading to the instructions. But maybe I'm making it too complicated, and that's why.
I remember that discussion. I remember us talking about that. You're absolutely right. And the way you can do it is you establish your law form first. That's where you claim your unalienable right, and then you go through. I see three things that every indenture should have, and the first thing is the establishment of your law form, where you claim your right derives. The second one is what we call the habendum clause, and the third one is a paragraph where you express repudiation, that you reject repudiation of the trustee's rejection or repudiation of its trusteeship. So those three paragraphs are an excellent start to any indenture. And I think that's what you're trying to get at.
Yeah, and let me ask you something while we're at it. The 5 W's, when we answer those questions, how specifically do we ask to answer those 5 W's? Like, for instance, just so that way I don't get misunderstood, what did they do to me? How did they do it? What's the actual question you should answer?
I don't think I follow. Are you talking about what we call the switches?
No. He's talking about when you put together a pleading.
Oh, a pleading. Okay.
Right. He's talking about pleading.
Pleading.
And Albert, that would be an appropriate model of thought in your putting together a pleading. And what we're talking about here is indentures, and the 5 W's, to the best of the indentures that I've been involved in creating, don't apply. That implies when you're making a claim, the 5 W's. And we're not making a claim here. We're simply doing the 3 paragraphs that Jeff suggested and giving orders. And there's no reason to make a claim in that situation. The claim that's been made is by the trustee, who is now holding the res. They've claimed that res.
Okay, so the 5 W's are really when you're going to court.
That's the context I understand that it applies in.
Yeah, it's kind of like you have something to prove. The indenture isn't a proof document. You're actually giving orders as the beneficiary and grantor. So you don't have to prove anything. You're just telling them what to do. That's a little different than going into court where they expect to see some kind of support for your statements.
Well, this proves that. Go ahead.
Christian asked us to add in, don't forget the granting clause. Bill in equity or courtroom counterclaim has the 5 W's. And also, I would like to share the definition of habendum before we proceed any further, and that's Latin for a portion of deed beginning with the words to have and to hold. The clause usually following the granting part of the premises of a deed meaning act, which defines the extent of the ownership in the thing granted to be held and enjoyed by the grantee. Continue, Albert. Sorry about that.
And I'll say that there's an audio where Christian actually speaks out what it comprises.
Yeah, I'll go study that one.
Yeah, there's that you can just copy it down verbatim, basically.
You know, this just proves to everybody that may be listening, you've got to ask questions. I wish I would have asked this one 2 weeks ago. I've been playing with those 5 W's. I'm thinking hamburgers right now. So
thank you so much for bringing that up, Albert, because we would have loved to save you the last 2 weeks of thinking about those 5 W's trying to do an indenture. Nothing would have pleased us more than to advance you through this 2 weeks ago.
I'll drove myself crazy with those 5 W's. Okay, you guys explained it, and now I'm wiping out the 5 W's, and I'm able to now see my paperwork cut in half. So appreciate it, guys.
And again, since the 5 W's drove you crazy, the value in going back and listening to the past recordings, you could have done that for the last 2 weeks instead of thought about those 5 W's and gained more foundational knowledge from NTT and possibly ran across the recording of how to put together an indenture and realize it wasn't in there instead of just trying to create indentures with the 5 W's for the last 2 weeks, huh?
That's why no one should think that they know without asking questions. You know, gotta ask questions. If you don't do it, you're gonna wind up wasting time like I did.
And worse than wasting time is also, what if you do it wrong and then you send it out and then you don't get the results you were hoping for?
That's right. You may not get that second chance.
Yeah, because what if it's for a trustee and you're dealing with a mortgage foreclosure action and you're now out of the house and living in the cold?
That's right, man. Very good point.
So please ask us questions, everyone. Please. Even though Albert sounds a little shy, he comes on and he breaks through that shyness to ask us. So please, everybody else, if we can help you, we want to. What else you got, Albert?
Man, I tell you, I'd like to sit down with about 10 of you guys and write it all out. Come on over. That's a joke, man.
Well, there is a way to do that. I mean, just go on to the NTT group and ask for a TA and get some personal help.
Hey, well, I would love to, do that. Talk to a TA group, discuss these things. I have tried, don't think I haven't. But
don't give up.
Yeah, I got to try a little hard.
Don't give up. You know what? Maybe we're testing your tenacity.
You got that right. Thank you, guys.
Okay.
Hey, Marshall.
Good evening. Good night, I should say. Hello, everyone.
Good to hear you.
Is this the Marshall that I used to know?
Yeah, it's me. How you doing, guys?
Good.
Doing good, Marshall. What are we talking about tonight?
Well, we were over the Christmas break. I went back through some of the old recordings, and I listened to 529 Remedy at Law, and we were talking about that and about the 2 reasons we might find ourselves in equitable jurisdiction, and that's because there's not an adequate remedy at law, and also to make an adjudication of the rights expressed by the facts of the parties. And so we talked about that. We used some of that context in CJS in Section 18 and 19 to apply the maxims for practical application. So that's what we were talking about for about 2 hours earlier. And then we started taking some questions and answers. And Darren came on and asked us about could we apply NTT in an administrative hearing. And then Albert was just on talking about how to write an indenture and the difference between a bill in equity and an indenture. And Dan came on talking about that he had a claim jumper.
A claim jumper?
Yeah, he has some type of action. It sounds like it's a real estate issue, and he just got a letter from a title company making a claim for some land.
Making a claim against him?
It sounds like it sounded like it was against him. Yeah.
Oh, okay. A title company. Interesting.
Yep. And we suggested that he could either notice them that they're in breach of the trust that he already did the withdrawal and redeposit on, or suggested that he could make them a co-trustee and give them duty. Either way, he could get them.
I think I'm going to bow out at this time.
Hey, Jeff, thanks for joining us, and we'll see you tomorrow.
Okay, bye.
Right. Good night, Jeff.
Good night, Marshall.
So how are things going in yours, in your world?
Busy, trying to work on some things and, get everything together according to how they're supposed to be. That's what I've been more focusing on, and so I can get back to my normal thing, my NTT thing.
Have you been working on your bill of replevin?
Excuse me?
Have you been working on the claim that was made against you?
Yeah, and that's exactly what I'm talking about. That's exactly what I've been doing, and putting together this paperwork. And the answer, since the action was being brought against me, I'm answering the action now, and the few elements that are contained within the answer that I had to get down packed, and just making sure that the actual documentation is together correctly.
In this effort that you've been so busy at, what have you learned that you could share with us that we can all learn from?
Well, to tell you the truth, this part of the action that I'm dealing with is more learning the process and the procedure and the form of the at-law side, and making sure that your evidence is in correctly, to make sure that your evidence is admissible, and the actual procedure itself. And I've been learning about the discovery and how important interrogatories, admissions, depositions, and production of documents, and how it is the best way to get your evidence into the court, and you can actually do a lot through discovery. And it's been more, I've been seeing a lot of chat about the jurisdictionary, and I just wanted to let everyone know that the jurisdictionary teachings are priceless. Without it, we need to be studying the actual at-law process and procedure side of things in order to be able to use our NTT process correctly and to its full potential and its full power, because we can know NTT like the back of our hands, which we've all stated before, but if we don't know how to get it into the courtroom correctly and have it recognized in the process and the form in which they are used to seeing, then we're creating issues for ourselves. So to tell you the truth, what I've been doing is, like the last NTT, we just had our birthday on the 7th, which, we celebrated, and for, I say, 10 months out of that year since NTT, well, I haven't even been studying trust for a full year now. It's been actually about 10 months for me, but as of the last month, I should say, I've been really focusing on the process and procedure, and what really started it was me having to answer to this claim. So I'm answering to the claim on the at-law side through defensive tactics, and for the most part, exposing all of the material alterations, or I should say the material facts and the holes that these guys come with when it comes to these public side summonses. Now, I'm going to get to NTT in a little while, but I just wanted to explain this one part first as far as the at-law side of the jurisdiction coming at you. Christian likes to compare them to two streams running concurrent with each other. One does not stop for the other, and it is very important for us to learn how to control both sides of the court at the same time, one being defensive and one being offensive. Now, the defensive side, if you were to have a claim coming at you, you would answer to the summons by having your affirmative defenses and bringing in your evidence and making sure that the stuff that they have in against you is right and exact according to the law. Because I've been reading also a lot about a lot of Supreme Court decisions here in North Carolina and appellate court decisions, and which comport to the rules around the state and everybody else's state for the most part. But if there are things about the evidence, and if you do not rebut the presumption of the admissibility and opposed to the admissibility of evidence, it will fly, because they would put in a bunch of paperwork that is not original, that has not been authenticated, that has not been sworn and attested to, and this paperwork, it flies by because we as the defendants, for the most part, fail to rebut the presumptions that these things are admissible as evidence, and you actually authenticate them yourselves by not rebutting and coming in with your own evidence. So it's little things like that that Christian have been teaching us for the longest now, where I'm really, really starting to see the importance of knowing our rules of evidence and knowing our civil procedure. Now, with that being said, well, just to be specific, I would also like to say that you would want to rebut the presumption and object to it. That is actually one of the documents that I'm working on right now. And the title of the document is called Defendant's Objection with Motion to Strike Plaintiff's Affidavit and Request for Hearing and Claim and Delivery. And this is all defense is what I'm working on now. And while I'm dealing with that side and answering to the public side of the summons, then I am going to come in with my offense of NTT and the trust. And now the NTT process that we use here in the trust is basically going to take over the entire proceedings, and by way of an injunction, it's going to totally put a stay on the entire at-law side and deal with it under the sole jurisdiction of equity. And you would be putting a stay on the at-law action. It would put a stay on it. It would totally freeze it until your rights are dealt with in a court of equity. And that court of equity, like I said, will totally put a stay and a freeze on the at-law side. And it's really all about juggling both jurisdictions at the same time. And you have to be competent and enough and have the understanding of the process and the procedure within these courtrooms. And once you understand that, you can attack them now on the equity side with NTT, because now you know how to get it in there and have it recognized and have the judge do exactly what he or she is supposed to do, especially coming in with these memorandums in equity. When you give them the control, when you give this district court judge or the trial court, the whole trial circuit, once you give them the authority of their bosses in the appellate divisions and the Supreme Court divisions, they kind of straighten up now, because that's setting up for an appeal, letting them know, listen, your boss ruled in this way, in a manner that is very similar to what it is that I have going on now. And if you don't do it, then I'm going to take it to your boss, and your boss is going to turn right around and remand it right back to you and say, do it the right way. So we might as well take care of it now and do it accordingly to the rules. And I've been really, really seeing, being that I had to actually hands-on do it now, I've been really seeing the importance of what CW has been teaching us and knowing what it is that we have to do to get through the gatekeepers into that magic door in equity. So to answer your question, Eric, that's what I've learned. Not that I didn't know it before, but it's really permeated into every single cell within my body now of the importance of knowing both sides.
And is it even possible that you could have gotten this far without jurisdiction, Eric?
Not at all. Well, to tell you the truth, to answer that question, honestly, I'm kind of lucky because I have one of the greatest teachers in the world who I can send a message to, and I can ask certain questions to him, and he is like jurisdictionary, to tell you the truth. But besides having CW, jurisdictionary is priceless, people. Priceless. Believe me when I tell you, it is so informative. It is simplistic. Like, it will take something very technical that if you and I were to just try to read it in a book or from out of the statutes or something along those lines, it will take that and break it down in layman's terms to where the average person with the quote-unquote average intelligence when it comes to understanding things that are contained within a book of a technical nature. It really makes it easy for you to understand. It shows you templates on how to put certain things together. Now, when you take that in accordance to what the Supreme Courts and the appellate courts are saying, all of the verbiage and it's just a whole beautiful mixture. But Juris Dictionary is priceless, and I'm so glad that I have it in my possession.
And if you didn't have Juris Dictionary, you wouldn't have had the level of questions to ask CW. You'd have been asking all the foundational form, process, and procedure stuff that you already got from Juris Dictionary. You were able to actually advance your knowledge quite a bit by already having it, weren't you?
Yeah, absolutely correct. Absolutely right, because I've heard Christian talk about discovery before. I've heard him talk about the importance of discovery, and like I said, production of documents, interrogatories, admissions, depositions. I've heard him talk about it. I'm not saying that CW didn't break it down in a term for me to understand it, because I understand when he tells me things, but the Juris Dictionary just took it and made it so much more simplistic. It brung it down to the 16th for me. Lowest common denominator, lowest fraction possible, so I can really understand it. And like you always say, Eric, once you learn the foundational principles of something like we do in NTT, then everything else, you build a great foundation, then I mean the structure that you put on top of it has something sound and strong under it. And those foundational principles are very important. And the Juris Dictionary, I'm really an advocate. I think the guy's name is Dr. Graves. Is it?
That's him. Dr.
Yeah,
Graves.
definitely. Well, I'll become an unpaid, what you call those guys?
Advocate?
Advocates, yeah. It's not the exact word that I'm looking for, but I'm an unpaid, yes, or an unpaid endorsement, I should say, for the Juris Dictionary. I've never met the man before. I've only heard of his work, but it is very, very important that you guys get your hands on that Juris Dictionary, because it will definitely make everything as far as the understanding of form, process, and procedure for the public side, which we need. And me, as a TA, telling you guys, for everybody that is listening, we can know NTT like the back of our hands, but I have really just begun to realize how important it is for us to master both realms. Although we don't want to look for our relief on the at-law side of the courts, we still have to learn how to travel through the minefield to get to where we are going in NTT and bring it in the right way.
And you can order Juris Dictionary through Christian, so contact Faith to Trust and get the link or whatever you need in order to order it through him. Right. And Marshall, in you're attaining the knowledge from Juris Dictionary and already having the knowledge of NTT and working in your case, how do you see things now at this point with what you're about to go into compared to before you even really got involved in your case? The way you see things, it's such a deeper level than you ever could have, and do you see things that, are you able to recognize things that you were unable to recognize, for example, before 3 or 4 weeks ago?
Right, well, to tell you the truth, I'm really starting to see things like a lawyer, to tell you the truth, because I'm seeing the rules that these guys have to abide by, and I'm taking those public rules and I'm finding where I can apply my private process, not commingling private and public, but knowing how I would be able to use a public manner of getting things done, but learning how to do it on a private side. For instance, before, everything about our evidence was make sure we have signatures on the seals, make sure we have 2 witnesses create a fact, whatever. We all know that. This is what Christian has been teaching us, and it's actually in the rules of evidence. It's in your evidence code. But to know how discovery brings in evidence, is very, very, very critical for me to know now, because when it comes to discovery, I can have evidence brought into the courtroom, which is a greater weight of evidence than just, say, an affidavit would be, because, say, for instance, in your interrogatories or your admissions, once you admit something or deny something and you have strict proof that would be admissible if you were to deny something, it becomes part of the record now. It is what it is. Remember, our affidavits are the lowest forms of a testimony, I should say, from a competent fact witness, and you would really want your evidence to come in through, say, a discovery. Interrogatories, admissions, the production of documents. I want the originals. I don't want to just see a bunch of copies that you guys are photocopying. For all I know, you could be masters at Photoshop, CS5, for all I know. I need these things, these pieces of paper that you call records, I need them to be authenticated. I need to know that these are true and correct copies of, or duplicates, I should say, of the original. I need to know that you guys are following the evidence code, because I am not going to authenticate all of this stuff for you. And it's those little things that I was never looking at before, as far as we making their case for them. Because to tell you the truth, most people don't even answer to the summons. They just get defaulted. They get a summary judgment put in against them, and it is what it is. They get a default. And then those very few people who actually do go into the courtroom and make it to the hearing and try to defend themselves or stand on their quote-unquote rights, they do it completely wrong. They do it completely wrong. They do not know how the evidence is supposed to come in. You don't know when you're waiving your right, when you're objecting, NOI, SOI. If you're objecting, you have to know the reason why you're objecting, and it's just being sharp and quick on your feet. Now, as I wanted to get back to the actual submission of copies now, you can submit a copy of something, but that copy has to be authenticated by the person claiming to own or have the original in their possession. You can't just stick in, and for everybody who may have a case going on right now and you actually have a summons that was served upon you, look at your documentation, look at the evidence that they have, and look into your evidence rules in your state and find out, because more than likely it's the same in every state, because I know I've looked in the Florida statutes because some Supreme Court rulings that CW has sent to me, and then I checked those and double-checked with my North Carolina statutes, and just for the hell of it, I'm from New York, I would check what it says in New York, and everything basically is the same. So look at the evidence, or the quote-unquote alleged evidence, and see if any of this stuff is even admissible to come into the courtroom as evidence, because it has to be admissible to the point where it would be used, can be used in a trial. And all of it is in your evidence code and civil procedure, and make sure that these guys are doing things the right way. Now, don't want to spend too much time talking about the at-law side, but it's just as critical to know the process and the form and the procedure on that side as it is to learn NTT and know that the elements of a trust are intent, parties, purpose, specific, trust, res, and a matter of delivery, or a way of delivery by way of our, I think it's for a 3811 green card slip from the post office. I mean, it's just as critical as knowing those elements, and that's what I've been learning, Eric. And there's a lot more that goes into it, but it's just a whole multitude of stuff, and balancing both of them, both sides in your mind, because a lot of people have problems with just dealing with one side or making the transition from debtor-creditor to trust. So now in this type of situation, not only do you have to know how to differentiate between the two jurisdictions, but you also have to make sure that you are not commingling or traversing into one side when you don't need to be there. It's like a perfect equilibrium. You have to really equilibrate this thing and balance it like you're walking on a tightrope in between two buildings, 800 feet in the air or whatever the case may be. So those are the things that I've really been learning over the last couple of weeks, and why I haven't been on the calls as much is because I'm the type of person that once I get new information, like, I can't even think straight about anything else. Like, that's what I want to do. I want to learn the new information. Like when I found out about trust and Christian Walters, I couldn't do anything else. As soon as I wake up, I'm studying, I'm listening to audios, and I'm doing that till I go to sleep. If I'm at work, I got it on my phone, listening to it in my earphones or whatever the case may be. Now, being that this was the first time I've really, how should I say, got into the at-law process and procedure and really digging into it, I tell you, the other...
Uh-oh, Marshall, did we lose you?
I'm here. Can you hear me?
Now we can.
Okay, so the other day, I went to the law library, and it's funny because I'm in there looking, I'm copied basically the entire forms book for injunctions, discovery, claim and delivery, and proof of record, and just a whole multitude of different things. And it was kind of flattering because I'm in there in my jeans and my sneakers and my ball cap on, my Yankee fitted and all of that stuff. But the guy was an older guy in there, and the public copier was broken, so I had to go to the guy behind the desk for him to make all of these copies for me of certain things, like what I just named. And he really turned around and asked me, like, sir, are you a lawyer? And, like, he was dead serious. And I looked at him, and I said, no, sir, I'm not a lawyer. And he said, well, where did you go to undergrad? And he started asking me what schooling was I into, and I told him the school at NTT. And, of course, he didn't know what I was talking about, but it was just from the type of information that I was seeking and interested in and photocopying is why he asked me that question. And we actually had probably about an hour-long conversation in regards to, I started asking him about CJS and all of that stuff like that, and he's just surprised that I even know about corpus juris secundum, because he said CJS, I said corpus juris secundum, and he abbreviated by saying CJS, but in American jurisprudence and certain other books that Norton's and Pomeroy's, and he was very, very surprised that I even knew about this information. And he asked me where did I learn about it from, and so I start talking about NTT and Christian Walters and blah, 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 and all of that stuff. And we had a great conversation. But the point is, the at-law side is very critical for us to know and learn, because once we know it and learn it, we can find how it applies to us in NTT and how to actually make it work for us by using that process, form, and procedure that they're used to seeing. Because I tell you, I'm so big on, like, discovery right now. I can't even tell you people how important to have discovery is. And first of all, let's take it back a little bit. These summonses that these guys put out against people normally never even rebut any of this stuff. I tell you the truth. This is a true story, Eric. When I first got word that I was being served with the summons, right, I'm trying to track down the sheriff. I'm calling him every day for about 3 or 4 days, and this was probably about 2 weeks ago, but the sheriff happened to be on vacation. So when I actually got to the sheriff, I got to him and set a time with him for me to be able to meet with him. And when I got to him, it was an older man, and he was like, wow, I've never met anybody that actually wanted the summons and seemed excited about it, like you were trying to really get to me, where everybody else, I got to run them down to find them. So long story short, I ended up getting the paperwork, finding the lawyer's name, and I actually called up the lawyer. So I actually was speaking to his paralegal first. She was giving me a little bit of information, so she put me on hold and transferred me over to the lawyer. Now, this is where it got a little bit interesting, because the lawyer basically told me, and he said his exact words to me were, it would make no sense, it would be a complete waste of your time for you to come to this hearing, because all that's going to happen is the clerk or the judge is going to find you in default and blah, blah, blah. I've been doing this for Wells Fargo for the last 10, 15 years, and I've done hundreds of cases, and it would be an absolute waste of your time to come down there. So I'm playing, you know, wise as a snake, as gentle as a sheep, and I'm like, well, there's still a couple of questions that I would like to ask when I get down to the hearing and stuff, you know, just being real naive about it. But it was interesting for him to tell me that it would be a complete waste of my time. So when I actually really looked through the paperwork, I see why he told me it would be a complete waste of my time, because if he did that 1,000 times, I can almost guarantee that it worked 999% of the times, or 999 out of that 1,000, and then that one person would come in there and change the whole game and turn everything upside down, because people are not looking at this thing for what it really is, and knowing rules of evidence and knowing civil procedure and knowing what laws apply to what situations, and just a whole bunch of stuff. And after I got off the phone with the lawyer, I bust out laughing, because I'm like, this guy really has no idea who he's talking to right now. Not saying that I'm some big shot and I'm like 100% cocky. I mean, it has nothing to do with that. But like our teacher has always been telling us, and like you've heard in many instances in life, the fear comes from the lack of knowledge. You're going to fear something that you don't understand. But if you understand what's going on and you know how to fight and you've been training, when it comes time to get into the ring, you may have a little bit of jitterbugs or something like that, but there's no fear. And I don't fear this situation because I have the greater weight of evidence and the law on my side. I just got to go in there and prove it. And then on top of that, I also know that I have a completely separate jurisdiction called equity that I like to say I've been doing a lot of studying on, and know some good and interesting things about it. And it's basically, like I said, I won't call myself an expert, but it's basically, I don't fear these guys because, one, I have a great teacher. Two, I have a very, very critical study ethic. Like, I'm just blessed to love to do this thing. I love reading these books. I love being taught. I love Christian drilling me sometimes when I don't understand certain things that he feels that I should just get right then and there. But I love that type of stuff. I love that teaching. I love to repeat things. I love to go over things a 1,000 times. And because of that love of how I study and how I like to absorb information is why I don't fear these people. The only thing is learning the actual process and procedure to where you would be totally right, but if you don't say it the right way, you're wrong. You understand what I'm saying, Eric?
Yeah, you got to speak their language.
Exactly. Speak their language until we get into that jurisdiction where the real people play around at. We want to go into that secret door. We want to get into equity, but we will not get there unless you master the form and the process of that fiction realm. You have to master it, and I'm starting to see there's no ifs, ands, or buts. There's really no getting around that.
Yeah, and once we get in the private, that's the realm where we speak our language.
Exactly. That's when we actually speak verbally. Right. You understand what I'm saying? And have our voice and our thoughts and our ideologies recognized, and you looking at me as a real fleshly sentient being. I am equity. I am what is right. I am what is just. I am the source, and you're going to deal with me accordingly. But in the public realm, everything is a mirror. It's completely different. I am fake over there. I am not real. I am everything that is contrary to equity when you're over there. But yet and still, you got to learn how to play around in that realm to get over to where the real people are. So to answer your question, that's what I've been doing. That's what I've been learning. That's how I feel my knowledge has expanded to where now I'm really understanding the procedure of how this court system works. Not saying that I know it all and that I know everything, but I definitely, over the last 2.5 to 3 weeks, I should say, have learned more than I've learned in the last few months, dibbling dabbling with the public stuff, because I've so 100% been NTT, and that's it.
So everybody who is on the call at this time and who might hear this recording in the future, do you guys hear the conviction in Marshall's voice? Imagine having that conviction going into your own case, instead of just feeling like, man, I don't know what to do, and I'm going to get hammered.
Right. No, I don't feel that way. Not one bit. Not one part of me feels that they're going to hammer me. The way I like to look at it is, I like to look at it like this. If I don't do this, they're going to hammer me. So I'm going to play devil's advocate with everything that I do. And most importantly, even in the public realm, I am making sure that I am creating my record every single step of the way, just in case I got to go talk to this district court's boss in the appellate level. And even if his boss don't get it right, then I'm going to go up another level and go to the Supreme Court and go talk to them. Somebody's going to get it right, because I know what this law says, and I can comprehend what this law says correctly, and you're not going to tell me anything different. Period.
That's being the private real man.
Right. That's you, Floyd?
Yes, sir.
How you doing, bro?
I'm doing just fine. I'm stuck in New York.
Are you in my part of the woods, huh? Well, it's been a long time since that's been my part of the woods.
Well, we had a lot of snow here.
Yeah, definitely. It snowed here in Carolina the other day, too, but of course it's all gone by now. But anyway, NOIs, SOIs, people. Creation of records, public side and the private side, it's the same thing. Your records are everything, and once again, I'm going to reiterate, for anyone who has an action coming at them, or anyone who sees an action coming at them, or anyone who feels they might have an action coming at them, look at this paperwork and go through your state's evidence code and civil procedure, just for the at-law side, because it's going to tell you a lot of things that you're going to need to know when it comes to an application of NTT through trust, even though it's two totally different law forms, two totally different jurisdictions. That is understandable. But remember that I believe it was in 1954, don't quote me on it, but I believe it was 54, where both jurisdictions were put into the same building. They weren't commingled, but you can go into one building and either be in a court of equity or you're going to be on the at-law side of the courts. Now, to get into that court of equity, there's a couple of things that you're going to have to do, which we all know that our teacher has been teaching us. But alongside that, just like those two streams, as he likes to compare it to, we need to know both sides. And when you know both sides, then you're going to really see the power in equity, and how equity will just shut everything down over there on that at-law side, where you can go into equity and get an at-law remedy if you can't be made whole for some reason in equity, or they can't compel the performance by your trustee. They're going to give you an at-law equivalent. But you can't go into the at-law side and say, I need some type of relief in equity. It's two different venues. But once you know that public side, as far as the process and procedure, not just statutes and codes that everybody loves to live and die by, when it comes to me, I believe the evidence code and civil procedure are the real codes that I need to know like the back of my hand, because 9 times out of 10, every action that comes against you, or almost 100% of the time, you could say it's almost definite that every action that comes against you is going to be an at-law action under debtor-creditor. So when it does come at you, you need to know how to respond to it. Because if you don't respond to it and respond to it correctly, you will be defaulted and you will lose. Now, you still have your big joker or your ace of spades or whatever you want to call it still in your back pocket through NTT and equity, but you want that transfer action. You want that dismissed from the at-law side and transfer that action because they are at their jurisdictional limits. So they had to dismiss it. There's nothing else they could have done. Use a transfer action and take that over into that second venue of equity through NTT and trust, and you're going to find that things get really interesting. So that's what I've been doing. That's why I haven't been on the calls. Like I said, I'm a very studious student, and I really want to get this stuff over with so I can get back to these calls and get back to listening to you, Eric, and the rest of the TAs, and answering questions and listening to CW and reading what Lisa has to post on the Skype chat windows and all of that stuff like that, because this stuff is like, it really take over everything that you're doing. So that's what it's been.
All right, cool. Well, I wanted to just give you that full opportunity to share everything you've been involved in, because we haven't heard much from you. The TAs haven't heard much from you, so we're everybody's interested to find out. And when do you have your next event?
The hearing date is set for January 4th. It's actually 1 week from tomorrow, but there's some discrepancies with that entire situation because the attorney, he kind of screwed up in a way, and I don't know if I want to use this to see if I could use it as an advantage of mine, but the attorney set the hearing when you get a summons. Now, in every state, it differs. Some states is 20 days, some states is 30 days. Now, upon the date that you are served with the summons is where your 20 or 30 days starts. Now, here in North Carolina, it's 30 days, and they actually set a hearing on the 25th day, which first of all, that's a violation of my due process because the law states that I get 30 days to respond to this summons, and they set a hearing on the actual 25th day. So, with that being said, I'm not under any 10-day rule to give any kind of a notice to the attorney. All I have to do is respond within 30 days and send the opposing party record of my response or send them notice of the response. And I'm trying to figure out whether I want to use that element, because he won't be able to per se claim surprise, but I'm thinking it's going to be a continuance or something along those lines. So I'm still trying to work that out in my brain. But the actual date was set for January 4th, which, like I said, is 1 week from tomorrow.
Well, look at it like this. Not much is going to happen there, so you might as well just plan on that you're going to basically have another 30 days to continue to sharpen your tools.
Right, that's exactly, because now that's what I was about to say, Eric, because right when I was really about to start really going in and working on my bill in equity is because I've been gathering a lot of information, and I still have to get on the call and really go over the bill in equity with everybody who listens in, because I had a couple of people contact me about this bill in equity, and as soon as I was ready to do it, because like I said, what I was doing was I was reading about 5 or 6 different books, and Book A will have something that Book B doesn't have, and Book B will have something that Book A doesn't have, and Book D will have something that A and B both don't have. And I found a lot of information that when you put it all together, it just makes one big, beautiful pot of the best gumbo you've ever eaten in your life. So right when I was about to get ready to do that, it's when the summons and everything started and put a whole complete hold on all of that stuff. But if there was, well, I'm kind of figuring that there is going to be a continuance, because the attorney, he's going to get my response and my answer, and he's going to like, oh my God, like, all right, this guy knows a couple of things. I need time, Your Honor, to respond to this. I kind of see that kind of happening, because if he try to handle it right then and there, he's going to lose, because all of his evidence, his affidavit, like I'm rebutting all of this stuff, killing these presumptions, NOI, SOI, NOI, SOI. Like I said, not being cocky or being sure of myself, it's me having the information that states, and me having these appellate court and Supreme Court decisions that say the same exact thing. So this is where the confidence comes in. So if he wanted to try to handle it that right then and there, it's not going to go good for him. So he's going to try to motion for continuance, and when that happens, now all of my paperwork is going to be basically in on the public side, and then that will give me the time to put together my bill in equity and stick that into the court, because like Dr. Graves says on the jurisdictionary, he gives a very great analogy, and I'm glad that he used it in such a vulgar way. But what he said was, when you pull the axe out, you don't want to just start swinging the axe. You want to bury that axe right in the middle of the other guy's forehead. I promise you, those were his exact words.
I heard it.
All right, and that is what I'm doing. That's why I'm saying, okay, if I get this continuance, that's going to give me the time to put together my bill in equity in NTT and to create, well, I already have all of my records and my breach of trust and all of that stuff created. Now it's time to pull the axe out and start doing a little bit of decapitation around this place around here. You understand what I'm saying?
Graves said, you're coming to an axe site. Bring your axe.
Bring your axe, absolutely. And when you swing it, stick it in the middle of the other guy's forehead.
Yeah, don't miss.
Right, and that's what NTT and this bill in equity and our knowledge of trust, that is going to be the equivalent of what that description that we just said. So I'm really excited about this. Like, a couple of friends of mine, they laugh at me like and say like, yo, who the hell gets excited about getting sued and having to go to court? And because they see, like, I laugh about it, and I got like a CSI chart that I've made in my room with all kinds of things on it, where defenses and offenses and laws, and because I took so many notes and I had so many papers of information and stuff that I had to see it. So I took the back of a board and put in a bunch of affirmatives and different laws and things that they're trying to use, and what I know rebuts and kills the presumption, and just to make sure that I have a flow chart or something that I would be able to look at and see to make sure that I am absolutely killing them on every single point that they tried to come at me with, and then come back with even more evidence of my own. And it works out great. And I like the way it looks, and it keeps certain things in mind. So when I look at it, I make sure that I'm not missing certain things. Like today, actually, I went back over the chart and found something real critical that I needed to stick inside of the paperwork, and I did it, and that was the main reason. And I got that idea from you guys and the rest of the TAs about the flow chart that we had with the process, the deep root process, and how we needed to be able to see everything because of the different parties that are involved. We wanted to make sure that both of the titles were not within the same place at the same time, because we know that would collapse the trust, and it would happen prematurely before we would actually want it to happen in the deep root process. So taking that idea is why I created a nice big chart, got it hung up on my wall, and just getting all of this stuff together. And I actually want to take it and do like some sort of a spreadsheet or what you call that program that you do the slideshows with? PowerPoint, exactly. I wanted to try to put it on a PowerPoint program or something along those lines so people would be able to see it, because it's some really interesting stuff. And I wasn't even thinking about the at-law side. I was straight 100% NTT until Christian said something to me one night which kind of changed everything and made me veer off onto a different course for a couple of weeks. And I'm so glad that he did that, excuse me, because he led me to another path that is absolutely 100% needed. It's like a counterpart to what it is that he teaches us 99 3/4% of the time as far as trust is concerned, but it allows us to see how that at-law side can run as far as process is concerned as a counterpart to that second venue of trust and equity and how to get in, and like I said before, knowing what the public side has to offer. And once again, jurisdictionary, you can order it through our teacher, Christian Walters, and I really recommend that you guys get the Jurisdictionary. Get it, please get it. It'll be one of the best investments. If you are the type that would love to defend yourself and you're not the type to just sign over all your rights from a power of attorney to an attorney and have your whole life and your home and your car or whatever the case may be riding in the hands of somebody else, if you're not that type of person and you want to do this thing yourself, one of the best things that you can do next to tuning into NTT and Christian Walters and NTT chat group and listening to all of those audios, the next best thing that you can do is get the Jurisdictionary from Dr. Graves and bring both of them together and just gel it together, because it's going to be beautiful once you really start noticing certain things as far as the tools that you would be able to use on the at-law side, but using them in equity. Because
and
even
then to top that off, Marsh, the other thing that they can do is once they get that and once they learn of what we've talked about on the calls again and again and again, is to come onto the calls and have discussion about the things that they're learning and the things that they're applying.
Right.
That's the next level up.
Right. Absolutely. Absolutely. So, like I said, the Jurisdictionary, people, is all about knowing the rules of the court, not to try to get you sucked back into the whole debtor-creditor realm of everything and just doing that whole general process that everybody's out there trying and been trying for the last 30 some odd years that don't work. That's not what the Jurisdictionary is for. The Jurisdictionary is for you to still have your NTT eyes or have your NTT glasses on, but it is imperative, it is mandatory that you know the rules of your courtroom. And that is what Jurisdictionary is going to explain to you. So please don't take it as an opportunity to get sucked back into that black hole vortex, debtor-creditor realm of nothingness.
A fiction land.
Right.
All right. Thank you, Marsh. That was a wonderful thing that you shared. And I'm going to suggest to everybody to go back and get the recording from tonight and learn from what it is we were talking earlier and about what Marshall talked about this evening. And please, is there anything else you want to add, Marsh?
No, that's about it. Just want to re-allege everything that I've stated over the last 20 or 30 minutes, and I've learned that too when it comes to your documentation. You have to re-allege certain things, like if you have parts 1 through 6 of your vermits and you go to second section number 2, the next thing you want to re-allege everything from part 1. So once again, I would like to re-allege everything that I said to you over the last 20 or 30 minutes. Like Eric said, get the call again, listen to it, but just learn how to balance both sides. Equilibriate, that's the word for the night.
And one thing I want to point out about the way Marsh is speaking and what we do here at NTT is it's NOI-SOI. And then once you start getting in the Jurisdictionary, you're going to learn how to put pleadings together, and you're going to find that a lot of the things that you learn from Jurisdictionary and here at NTT is very consistent in the way that we state a point and prove a point in life.
Right, absolutely.
It's really just basic communication, but there's specific ways to do it with a form, process, and procedure on the outlaw side, and then a way to claim it and prove it in the private.
Absolutely.
So it's just another manifestation of good communication is really what it is.
Yes, sir. Yes, sir.
Marsh, thanks for coming on tonight. It's such a pleasure to hear your voice.
I appreciate it. Thank you.
And thank you to the other TAs and to the people that came on and asked questions, Darren and Albert and Dan. And please, people, take notes and don't be shy about coming on. And please join us next Monday at 10 p.m. Eastern Time for another Trust Ambassador call. And then tomorrow night at 10 p.m., same time, same PIN code, Christian will have his normal Tuesday night call. And then we got Talk Shoe on Wednesday. And again, for newbies, please contact Faith to Trust to transcribe the calls, and that's the best way to learn what it is that we're talking about NTT, and then to get the list of recommended reading materials and the links for the recordings to download. And if you want to sign up for the Beginners NTT 101 course, please send a email to Moving Titles at Hotmail, and in the subject line, it is essential to add NTT registration application. And when you send that to Christian, so he'll know what it is, and he'll actually take a look at it. Thank you, everyone, for joining us, and we'll see you tomorrow night at 10 o'clock.
Have a great night, everyone.
Good night, all.
Good night.